Charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not
You will bring the jury.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy. The dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case.
Literally not true.
Dati mihi Anglican police, verbal blood.
Is that correct?
I didn't ask you to interrupt me. Oh, for Trump's sake.
All right, welcome back to the Court of Public Opinion. I am the Recovery Addict. Happy Monday. Has anyone's Monday gotten a little better? Just a tiny bit? I think they all should, with maybe the exception of Greeners, who was first in chat this afternoon. Greeners, your Monday just got worse because everything IP-related worldwide is now your responsibility for the rest of the day. You should think about that before you be first in chat next time. It's gotten better, says Clever Name. Not warmer, though. Greeners laughs with an evil laugh. I heard that one, Greeners. I could hear it in my head. All right. Hey, look who's in my studio. Hello. Hello.
Hi. I was wondering what your favorite candy bar is.
Well, we have a special guest, Little Miss R.A. My favorite candy bar?
Yes.
Oh, man. Can I go with the Hershey's Cookies and Cream?
Yes.
I'll have to fight. Okay. What's my favorite candy bar? I like Butterfinger, but I can't. You spend all day picking it out of your teeth afterwards. Hershey's Cookies and Cream is a big win. Any milk chocolate symphonies? That's good if you want to go less wax. Symphony milk chocolate.
Do you mean the nuggets?
No. Like the candy bar. Symphony makes a candy bar.
Oh, I did not know that.
Yeah, it's really good. And how many do I get?
Well,
Just
she's
one?
the magic maker for the candy, so she wants to know.
You can never go wrong with a Snickers.
Oh, you can.
Not a sponsor, by the way, yet. Mars Candy Company, hit me up. Let's do something here. All right, welcome back. Welcome back. Reese's all the way. Heath Bar. As long as it doesn't have coconut in it. And no dark chocolate.
Almond Joy, baby.
No Almond Joy. I'm sorry. Almond Joy, Mountain. They're out. Pretty much anything that yuck. No coconut. All right. I think she's in charge of procuring certain candy bars for stock. We have a tradition where we put candy in people's socks here around Christmas time, and she's in charge of that this year. So. Danny Austin, member for 32 months, says OG. Yes, you are, in fact. In fact, is better than farked. Fact. An OG, Danny Austin. Thank you. 32 months. It's wonderful. I think that's the first time she's been on the program. My daughter. She was a little shy about it. She's quiet. Nestle's Crunch, good. Good in ice cream. Make a blizzard with Nestle's Crunch. That's really good. Twix is my favorite, also delicious. I know what we're talking about the rest of the day. No coconut. I love Mounds and Almond Joy. Those two are out. They're gone. And like whatever the Almond Roca, whatever, that's out as well. Those three gone. Do you know anything about MetaQuest 3 in the vest? I can't figure out which cords I need. I know a little bit. About MetaQuest 3. Yes, now. Thank you. The vest, the haptic vest, I know it was on sale on Black Friday. You might have been able to pick it up for like less than, I think it's normally $300. I think it's $250. The haptic vest is, I don't know how it connects cable-wise. I can Google it. I wouldn't Google it. I would actually use X. Let me do some homework on that one, and I can tell you, Bree. I've heard great things about those who like to play. It's a very immersive experience because you feel everything. And it works for music as well. All right, it's a candy stream today. Yes, we saw her in the Halloween stream. Yes, you did. In her crime scene outfit. She was on when you showed us the flooding. Yeah, she's made a couple. I don't think she's talked before, has she? Maybe she has. How many of your family traditions involve candy bars? All of them, if I have any say in it. Greeners, everything. Three Musketeers is good. I'm a big fan of the whole like transition all the way up to Milky Way. So you've got Milky Way, you take away the peanuts, you've got Snickers, you take away the peanuts, you've got Milky Way. You take away the caramel, you've got Three Musketeers. And then if you take away the nougat, you've basically got Hershey's chocolate. It's just a different shape. So that whole line is good for me. Rachel B., member for 13 months. What is said in the intro after "that's literally not true"? I hear something along the lines of, "That's not going to be an Anglagon for you." Well, I'll play them quietly. We have this one.
Dati mihi Anglican pros verbis Latinus.
Is that one? Because that's Latin, and nobody knows. Nobody knows. I guess somebody could do it. Somebody could translate that for me. It might be the judge swearing in Latin. I don't know, but I think it's like some legal thing. We've got that. We've got.
That's literally not true.
Is that correct?
I didn't ask you to interrupt me. Oh, for crumb's sake.
That's all I play. Those are the only ones, usually. So hopefully that helps. Daha igli Anglican means I am English speaking.
Dati mihi Anglican pros verbis Latinus.
Daha igli Anglican. I'm speaking English for the purpose of the court or something. I don't know. I don't know what it says. You'll have to ask Judge. I now can't remember his name. Schroeder. All right, where were we? I was in the middle of a thought before I was so rudely interrupted by someone asking what candy I like. Thank you, Little Miss R.A. Let me turn that down because it's just buzzing. It's the microphone picking up the fan. We're going to court is what we're doing. That's what we're doing. Because it's court hopping day. Judge Boyd was supposed to have a trial this afternoon. I think it starts, there's Central Time, right? I think she's Central. So we've got a minute before that. I recognize that from my high school. We learned way too many Latin phrases. Is Judge Schroeder still judging? No, he's retired. He might be doing like family law cases, but as far as like hearing criminal cases, I think he's done. Yeah, he was a little long in the tooth, you might say. He'd been around quite a while. It's awesome to have that much experience, but it's awesome also to just retire and let somebody else do it. And he was at the retire and let somebody else do it stage, which is good. Okay, let's see if we can jump to somebody else while we wait for Judge Boyd to come around. Judge Cedric Simpson. Judge Cedric Simpson, YouTube. It's weird that I memorized like the actual thing you have to say into the mic to make it work. Okay, so he is here. Let's see what we've got going on. Might have some landlord-tenant issues.
Court calls the case, People versus Christopher C. Lake.
Alexander on behalf of the people.
People, that's criminal.
Your Honor, David Rudoy on behalf of Christopher C. Lake, who is present and making his way to the Val.
Did he just walk in the door? Yeah. Okay.
Perfect timing.
No, he didn't. Your name, sir? Christopher C. Lake. All right. And what are we doing?
Your Honor, can we briefly approach, please?
Every other case has. Why not?
All right. Yes, we did get a verdict in, by the way. We got a verdict in this morning. It was about an hour in, roughly. I think an hour more deliberation this morning. Then the jury came back with a verdict. And it was good. Josh, I'm about to send you 3 options to jump to that are live. I just received them, Josh, so thank you. Okay. Oh, it's DV. Oh, man. This one's DV, which means we've got to bail. Instead, we're going to go. He gave me 3 options. Josh, this is like. Did you snip the answer to the questions 97, by the way, for me? I have it. I didn't snip it. So that... Okay, go to this one. Let's see if we can get here. Josh has sent me on a wild goose chase. Right, I was muted, but we're here. Josh sent me here. I don't know why. He says, go to Hasselink. Ma'am, what are we doing here?
All right, the next matter is Mary Jo Sarascani versus Timothy Lasario. File 24-39533-SC.
This is civil.
Yes, I'm here.
Can you pronounce your last name for me?
Sarascani.
Sarascani. All right, thank you very much.
You're welcome.
Who do we have on behalf of Mr. Lasario?
Crickets?
All right. There is a notice to appear for today's hearing at 12:15:25 at 1:46. It is now 1:59 p.m. Mr. Lasario has not appeared at the call of the court. Plaintiff Ms. Sarascani has appeared. This is set for a civil discovery subpoena matter for the defendant's failure to appear. We'll do a bench warrant.
Bench warrant in a civil suit. Nice.
What that means, Ms. Sarascani, is I can't grant you any relief because what you're looking for is information from him, and I don't have that information. But what I can do is issue a warrant for his failure to appear, which requires him to appear, and then I can notify you once the police find him, and then we can get another subpoena to do a civil discovery thing again once we know where he's at. So in the meantime, all you can do is sit by and wait until we find him. The court will then notify you once he has been found. You can repeat your subpoena at that point, and we'll do what's called an arraignment on the bench warrant for his failure to appear. I'll set bond. One of the things that will be required is that he appear, and then we'll know where he's at. And we can go from there. Any questions about that?
No, sir.
All right. Thank you for your time today. We'll see you in the future.
All right. Thank you.
Nobody's even there.
We'll set a
Oh, now you're back.
$2,500 bond.
We're sort of looking at the ceiling here. It's beautiful. I like the ceiling fan. I'm always a fan of that. I like the railing. Lots of size.
Next matter is the Bank of America versus Cindy Hopkins, file 25-40371-GC. Who do we have present for that matter, please?
Good afternoon, Your Honor. Timothy Trumberth on behalf of the plaintiff, P79117.
Thank you. I do see Ms. Hopkins with us. Ms. Hopkins, can you hear me?
Yes.
All right. Thank you very much. This is a pre-trial matter. It's like there's a credit card outstanding. There's a claim for a little over $3,000. And Ms. Hopkins has answered in a handwritten letter, basically saying that she can't afford the bill and would like to have this written off. Counsel, I'm assuming that your client is not willing to do that at this point.
That is correct, Your Honor.
Would it be of assistance to have the parties in a breakout room to try to discuss the matter and reach a resolution?
Yes, sir.
I did speak with the attorney, Natasha, and she did offer me a settlement, and I have a friend who's going to help me with it, so I'm willing to make the settlement.
Oh, you are? Okay.
Yeah.
Sure. So you're willing to agree to that, what was agreed to previously?
Yes.
All right, Your Honor, may I put that on the record?
They were about to.
Yes, please.
They were about to get a lower price.
I believe the offer was, well, the current balance on the account is $3,043.52.
Correct.
The parties have agreed to resolve this for $1,830 over 24 monthly payments. Is that correct, Ms. Hopkins?
Yep.
Okay. Did you guys set up a start date?
No, she just said we could do it here, or I can work that out with you, I guess.
Okay. Would the 16th of January work for you?
Sure.
Okay.
The bank's just happy to be getting money here. They would have basically had to write this one off almost.
And that will be in the form of a stipulated conditional dismissal. Once the paperwork is entered with the court, the case is dismissed without prejudice.
So they took out the late fees.
Let me get the exact payment amounts as well. I apologize, Your Honor.
Oh, that's quite all right. Take your time.
So it looks like it'll be $76.25 per month on equal payments. Is that acceptable?
Yes.
Okay.
All right, go ahead, sir.
Oh, Your Honor, would you like me to get the defendant's consent to sign for her, or would you rather us exchange the paperwork and have her sign, and then plaintiff will file that paperwork with the court?
Let me just ask on the record. Ms. Hopkins, you've heard what the attorney has said today. Is that your agreement?
Yes.
Has anybody promised you anything or threatened you in any way other than what's been stated on the record here today to get you to do that?
No.
Are you doing this of your own free choice and free will?
Yes.
And do you agree to allow the attorney to sign your name to that document so that he can submit it to the judge, to me as the judge, so that I can sign it to make it a court order?
Yes, please.
And you understand that by doing all of that, this would be a requirement and an obligation on you, and it would be a court order that can be enforced in the future.
Correct.
All right, counsel, it appears to me that she's entered into this freely and voluntarily and has given you permission to sign her name to that documentation. If you would simply do that, send a copy or send the original to me so I can sign it, and then we'll get copies to everybody. I think that will solve the matter.
Thank you very much, Your Honor. We will do.
All right, thank you very much. That's all for today then.
Thank you.
Take care.
Welcome.
Hang on, I'm trying to get Mrs. R.A.'s phone connected properly here. Hold, please. You have to put your face on this one.
Can I tell a story while he's getting this? My face? I don't think it's my face.
Yep. You need your face.
Not my face. It's the password, but I don't know that password.
If you do it again, you can
hold, please.
Hit install, and then we'll need your face on it.
No, I hit install. That's what it says. Okay, so here's the situation. This year, I'm dealing with like some guilt, and yet not guilt.
Double click and look at your use your face. There you
Got
go.
it.
Perfect.
Thank you.
I need my face on your phone.
Okay, so here's the situation. This year, for Christmas, for the goodies that we took to people, I decided to take it to people.
Cookies.
Yeah, they're just cookies. I decided to take it to people who have just gone through something, right? They've just moved. They just had a baby. They just had a spouse pass away. They just had, I don't know, people who need a little lift. That's basically what my list was made up of. And this seemed like a really good idea at the time because, you know, they need a lift. Here's some cookies. Here's a lift. But what I hadn't anticipated is that one of my proclivities, which is to decide to do something and then do it really early and then be done with it, is coming back to bite me on this one. So we took all these cookies out to all of these people who weren't expecting it, and I think they were happy and I was happy with it, and it was done. But then these same people who have just gone through something traumatic and are having a hard time in their life now feel obligated to give something back to me. And they are they have all this time to do it because I did it early, so it's like I set them up so that they absolutely have to give something back to me. I feel really, really bad about this, except I went through something earlier this year. One of RA's mods was in the hospital, and I'm sending him 2 pounds of pecans arriving tomorrow.
Josh wants cookies.
Okay, but Josh, apparently you have to like give something back. So these people are bringing me homemade goodies and stuff, and I feel really bad about it. And I'm grateful. It's awesome that they're doing it. And somebody last night, they brought us this chips and salsa, and I was like, wow, thank you. And then today for lunch, we opened it, and I was like, oh my gosh.
It was so good.
We have to be friends.
Yeah.
It was delicious.
We're going to give them more cookies, hoping they have salsa left over.
I know. It's this homemade salsa. I don't know when they found time to do it. They just had a baby. But it was just amazing. And I was like, I feel so bad that I guilted them into bringing this accidentally. But by the same token, I'm like, could you give us more? That was so good. So that's it. Have you got the phone happy?
So yeah, you go to, like, you got Amazon.
Are you showing them?
Yeah, you got Amazon here. And you go to your account down here, this little person.
Yes.
And it says your returns, and you say see all, and it has all your returns with instructions on what to do.
Good.
And you can click on each one, just show them the barcode.
Okay. I'm trying to get some happier clothes to wear, but I'm so
Use for happy
picky.
clothes.
So, okay. Good talking to you guys. See ya.
Okay. That was all. Okay, thanks for this little interruption. The best baby gift, especially for multiples, is banana bread. Banana bread. It's good stuff. Allie B from Tennessee, member for 31 months, says, Mrs. Ray, can you just send me a handwritten Christmas card? I don't think we've ever done. Oh, well, Mrs. Ari might have. I've never sent out Christmas cards, which is sad because I've been receiving several from many of you, and they're amazing, and I display them on my mantle. But I've never been that organized. Okay. Alex, the Dana Mom, I think I got yours. I've got 4. I have a terrible memory, but I think I've got yours. Hang on one second. Let's go back to court.
Correct.
If he doesn't do that, then it would start the clock running for the 10 days for him to be out, and eviction would be available after that 10-day period of time. Is that what you understand, Ms. Smith?
Yes. Does that 10 days start from today?
No, it would start from the date of
the 25th?
last. Correct. The date that it last would be due. So it'd be 10 days after that. So it'd be January the 9th or the 10th or whatever that,
10 days after, so, okay.
Yeah, 10
so
days
it'll be
after the 25th, whatever
Communication
that date
goals,
works out,
screeners.
January the 4th or whatever it is.
Yep.
Mr. Garrison, do you understand that?
Yes, I do.
All right. Let me see if I have the appropriate, I don't know if I have the appropriate documentation in front of me to do that. All right, Ms. Smith, I do not see a proposed judgment in the file.
Allie B, you are an OG.
So what I'm going to ask you to do is to submit. There should be a form, and if you don't have it, you can ask the court staff. Ms. Good is with me, so she'll remember this if you call her later this afternoon to get a judgment.
What's that form number? Because I'm sure I have it. I'm sure I have one here.
She's just walking around.
I don't know it off the top of my head. I don't. If you can't find it, call Ms. Good this afternoon in another hour or so once we're out of court. Another half hour when we're out of court, and I'm sure she'll be able to tell you what that number is, and you can prepare that. If you would send me that form with 10 days from the date that the payment is due, the 25th, and then the total of the $1,575 amount that's due, and then just indicate that you will put a sticky note or some other note with it that says you'll call after Christmas as to whether or not he's made that payment.
Okay.
And then if he has made the payment, you can indicate that to us and we'll
Okay.
hold off on the enforcement and go that way. Does that make sense to you?
Yep, that makes sense to me. I've done this numerous times, so yep.
All right, Mr. Garrison, do you have any questions about that?
Not at this time.
All right, that's what we'll do then. Hopefully you'll make the payments, so we won't have to worry about it, but if not, you'll have your 10-day period running after the 25th. All right, thank you both very much. That's all for today.
Thank you.
All right. Well, I've never been to this one, I don't think. Have we been to
From the parking lot and
this trail in Michigan?
out of there.
Okay. All right. I will continue the bond as previously set under the $250 with the additional conditions. Ms. Hughes, that you appear as ordered, keep your contact information current, not leave the state without permission, and to commit no new crimes. I am going to order that you not consume any alcohol, and you'll be subject to random testing. So how that works is your next steps are you're going to go back out to the front window where you checked in, get your next court date. You'll probably have some paperwork to fill out for the defender's office, and then you'll need to go downstairs on the ground floor to community corrections and get signed up for testing with them. Okay? Do you have any questions for me? Okay. All right. You can go out to the front window where you checked in. Court next call is the people of the state of Michigan versus Catherine Kuhn.
Fixed it. Just kidding. I fixed it for real. Sorry. I thought you guys were making a joke. I'm like, I don't understand what the coup was for. Didn't realize I had spelled it wrong. All right. Trying to find a little case, a fun case we can hop in on. Not big on credit card late payments. Let's see, Judge Simpson is doing landlord.
All right, sorry about that. This is the case of the people of the state of Michigan versus Catherine Kuhn, case number 255070SM. We lost the prosecutor and the public defender.
Case dismissed. There you go.
I found this back. Ma'am, did you have the opportunity to meet with somebody from the defender's office today?
I have not.
You have not. Did you read and sign this advice of rights form?
I did.
Is the contact information on the back accurate?
Yes.
Okay, stop. We're going to jump. I've never been here either.
We'll get that date to you too. In the meantime, Merry Christmas.
Merry Christmas. Oh, that was it. That was the end. I just wanted the eye in the sky view.
It is alleged that you committed the offense of larceny, $200 or more, but less than $1,000. That is a misdemeanor, punishable by up to 1 year in jail and/or a fine of $2,000 or 3 times the value of the property taken. Do you understand those charges and the potential penalties?
I do.
You do have the right to be represented by an attorney at all phases throughout this process, and if you could not afford one would be appointed to represent you at public expense, but you may be required to repay a portion of that expense. Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney? The court will make a referral to the public defender's office for the appointment of an attorney. Will enter a not guilty plea on your behalf, and will set the matter for a pretrial. That's where your attorney and the prosecutor will get together to see if there's a way to resolve the case short of going to trial. You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public.
Larceny is the unlawful taking of someone else's property with the intent to deprive them.
I am going to authorize a personal recognizance bond in this case, which is your promise to come back to court. You are to appear as ordered, keep your contact information current, not leave the state without permission, and to commit no new crimes. I'm also going to order that you not have any contact with Robert Spoor. No contact means no contact of any kind, not by phone, text, email, social media, or anybody acting on your behalf. This charge does require that your fingerprints to be taken, so I have signed a fingerprint order. You'll need to get a copy of that order at the front window where you checked in, and then contact the Wexford County Sheriff's Office to get those prints taken. You have to have an appointment. You can't just stop in to do that. And as a condition of your bond, I'm ordering that those prints be taken by December 30th. Do you have any questions for me? Okay, you can go out to the front window where you checked in and get your next court date. Have some paperwork to fill out.
Ma'am,
Okay,
don't take the pen from the court.
That completes my docket, right?
That would be bad. Your docket's done, Mr. Wiggins? I think he's done. He wants to be out of here. Let's see if we have any more. Man, it is so thin right now. Judge McBurney's live. Now let's go to 2.
You know, the board does not. The board guards its votes, and I'm sure you're aware, everything official business the board does is guarded zealously. It's a state secret. They're not.
I do know we've had to litigate this in other cases, and why didn't this guy get parole? None of your business is what we're told.
They are zealous in protecting the privacy to afford individuals the most, objective review that they can do.
Oh, and I respect that. I didn't mean to probe in that way. Like, hey, who voted for this? I'm curious if there was some indication as to not who thought it was a good idea or a bad idea, but we are suspending because we need to do X, we need to do Y. That would give everyone a better sense of, for example, do we need to do this hearing? Do we need to do it today, or would we reconvene in a week or a month? And in between now and then, petitioners, lawyers might be able to learn some information that would make their argument moot, or who knows. But it sounds like you didn't get along with this, a little memo saying, hey, here's why we did this.
That is correct.
Okay.
And I will say, just factually, even if they were to, as your hypothetical, at any point file a new order saying, we are going to have a hearing on this date, I think we still have to go forward with the legal issue before you court.
Okay. And from your experience, when they unsuspend things, do they unsuspend and say, we'll see everyone in 20 minutes for the clemency hearing? Or there's a week's notice, or?
Yeah, I don't know that I can give you an exact time frame, but it's not the 20 minutes. I mean, it certainly is, they would get the same notice they would get anyway, normally, I would think. So, there's.
I haven't been on death row before, so I don't know what kind of notice you get for, hey, now is the execution date, and T-3 days is your clemency hearing, or how that goes.
If I may, Ms. Smith, who is the in-house counsel essentially for the board, is on Zoom.
Okay.
She may have
bring her
some
on.
information.
Oh, right, Ms. Smith. This is the Ms. Smith that one of you emailed to say we've got an issue, and nope, there's no issue. We're going forward.
Correct.
Ms. Smith, are you able to hear us?
Yes, Your Honor, I am.
Hey, thank you for joining us. Are you in a position to answer any of the questions that I had, such as how do we figure out why things were suspended? I bet I know the answer to that, which is no. But how much notice people get when the suspension is lifted?
So I may be able to answer, Your Honor. In this instance, I don't believe that there's any law regarding the amount of notice a person gets when the stay or the suspension is lifted. We would provide at least 24 hours notice, if not, depending on whether the window for execution is still open, obviously, to provide counsel an opportunity to get themselves and any staff that is assisting present to the appointment, which would likely be, like I said, maybe 24 hours in advance of the appointment date, should the stay or the suspension be lifted.
This is a hearing about death row. There's someone trying to get clemency on their.
But if there's supposed to be a clemency hearing before the execution, then I guess the execution would have to be at least 2 days out because you'd have the clemency hearing in between the lifting of the suspension and the execution.
That's correct, sir.
Okay. All right. But as of right now, you don't have any information you can share with the parties to this litigation as to whether this is a short-term suspension, a long-term suspension, or we wait for the next gold seal document.
That's correct, sir.
The last one?
I'm sorry. I don't have any information as to how long this suspension will last.
Okay. All right. Well, you didn't know you were going to be put on the spot. Thank you for pitching in here. That's helpful.
So execution is scheduled for December.
Okay,
17th.
we should go forward.
We should.
Because we don't know
We don't know this.
when we'll all be together again.
Wednesday.
Well, and the execution warrant is open till the 24th, and there's a massive amount of logistics of getting other witnesses here for the clemency hearing. So
He's convicted
The
of killing
24th
2
of
people.
December.
correct.
2
How
ladies.
does that work? An execution warrant is valid for,
A certain window, and so they could potentially say, hey, stay would be lifted tomorrow. Clemency hearing, execution is on the 23rd. We're going to have a clemency hearing on the 22nd.
if
And
we go past the 24th, then there needs to be a new execution warrant?
that is correct, Your
And
Honor.
is that what the district attorney applies for, or who? So Ms. Allen out of Cobb would say, all right, we have to do this
We have to-
again. I'm getting a new execution warrant. But is that merely a matter, I don't mean to make it sound insignificant, but he's been sentenced. So getting another warrant, some judge doesn't have discretion to say, I'm not going to give you an execution warrant.
Yeah, that's a more ministerial function, but it's also a large, over the holidays especially, a scheduling function, given that there are mental health experts on behalf of the defendant and other individuals who have to fly in. And
None of this
so
is
this-
simple. I get
this is
that.
a-
And
this is
so
a
no one
death
should
penalty
hopefully be
case.
thinking, well, we'll just give everyone 24 hours notice. I want to be mindful as we're working through this, the significance of if something pushes past December 24th, one can get another execution warrant, and that's not moving a mountain. What's moving a mountain is the execution and the clemency hearing and being prepared for that.
correct.
Okay.
Yes.
All right.
Yep. Okay.
So let's assume that we're going forward.
Yes. Thank you.
By going forward means going to the end for him.
This mandamus action is necessary because the state will say intends to proceed at some point with a clemency process that is plainly unconstitutional and cannot be remedied through ordinary channels. And this court does have the authority to compel compliance with the Georgia Constitution.
If Ms. McCoy doesn't participate, and by that I'm going to just say she's there the whole time, but she doesn't vote. That's how I take abstain. Abstain would be, I'm in the room, I might even ask some questions of witnesses, et cetera, but when it's time to vote, the vote is abstain.
Yeah.
If that's the approach that the board takes, which is what's been represented in signed pleadings that have been filed with the court, so that there are 4 people, and I appreciate you've got concerns about Mr. Bennett. We'll air those out. What's unconstitutional about that happening?
So, and it's a great question. The Georgia Constitution mandates there shall be a state board of pardons and paroles, which consists of 5 members. And that's Article 4, Section 2. And it further requires in capital cases, the full board have an opportunity to hear the application of a convicted person.
The board meets tomorrow.
The provision requires that clemency in a death penalty case has to be considered by a fully constituted 5-member board, not a partial one, not a conflicted one, and having all 5 participating members. It was recognized
They have a
10 days
technicality
ago
issue.
by the board's counsel, Ms. Smith, saying there have to be 5 members.
Well, but Ms. Smith isn't the Constitution, and so she said what she said. If the Constitution says that 5 must hear it, that might explain why Ms. McCoy would be given the advice of you should abstain as opposed to recusing, which I would take to mean I'm not going to be in the room while it happens. And so then 4 people would hear Mr. Humphrey's plea for clemency, and that would be inconsistent with constitutional language that says the full board must hear the application. But Ms. McCoy could hear it if she's abstaining. She's just not voting on it. I know that sounds ticky-tacky, but words have meaning.
But they do. And sorry, I don't want to interrupt you.
No, but so the full board hears it, and then Ms. McCoy says, I'm going to abstain. I ought not to vote on this because I have some conflicts that kind of hit you in the face when you read about her connection to the underlying case that brings Mr. Humphreys before us.
And they do. And so if you even dig deeper, so the board has a policy.
Mr. Humphrey
Board
killed
policy
two ladies.
1.120 that members, it focuses right on members are participating in proceedings.
2003.
And so the impartiality, if it's reasonably questioned, they do have to abstain, but a member is prohibited from participating. They are not exercising their constitutional power of clemency at all. And so the board cannot be constitutionally whole. And they make this distinction, I think, if you look at Fugate, for example, which this court decided in 2002.
And so we're clear, this court means Judge Goger.
Judge Goger,
not Judge
you,
McBurney, not a judge
you.
back then.
Right.
But you did, I looked at Fugate, that was in some of your pleadings. Does a policy of the board constitute either, and it may be both, a law that a judge could issue a mandamus on, you must comply with this law? Or is it a policy? And it's not a court's job to enforce a policy. And if it somehow is, well, start with that.
Okay, so I do think that policies are part of what we recognize that the board has to comply with. There are structures and norms for a board that they have to follow, especially when it comes to conflicts in this specific instance, right? And we're looking at what are these ethical guidelines that are clear, and when clemency is exercised, when we're looking at participation, deliberation, and voting for in these particular instances. And so those norms and guidelines help establish when a board member, for example, is conflicted, when there's an appearance of a conflict, and when it is the right time for that board member to not be participating in a procedure.
And what's the specific language of the policy if I, as a board member, conclude that I have a conflict, like Ms. McCoy has, apparently. She's abstaining. Does the policy say you should abstain? Does it say you shouldn't participate? And then that's open to the interpretation of, well, abstention means you're not participating. So she's checked the box of the policy, but you still have a full board because all five are in the room when the clemency petition is being presented.
So if you read at
This is last minute death sentence
under
appeal
board
going on
policy,
right here.
so the first board policy that we start with, which is 1.105,
Heavy stuff.
that the employees shall make every effort to avoid even the appearance of a conflict of interest. And it goes on to say that it's when a reasonable person would conclude from, I feel like there's a question coming.
No. With Ms. McCoy, I'm glad we're not having to have the argument. How does someone not see the conflict here?
Okay.
And that was addressed with the pleading from the respondent. So she's raised her hand saying, I've got a conflict.
Okay.
And so she's going to abstain.
All right.
How is that approach to her conflict inconsistent with the policy?
So 1.106, an employee shall recuse him or herself from any proceedings. It isn't abstain, it is recuse.
And what's the difference?
So abstain is, I still stay in the room. I can listen to all of this information, but I'm an empty seat. I don't vote on it. There's only 4 people who are there, Recusing is generally, I'm taking myself out of the room, I'm not participating in these proceedings. And it's like, for example, if a judge recuses from a case, we don't have an empty chair with this hearing going on. We have a new judge that's appointed in your stead.
Do you have any examples of recusals on the board where someone said, I have to recuse, that's my nephew who's coming in, so I can't be handling his request for clemency? And you know what they did in that case is that board member McBurney leaves and they bring in board member Jones, a new person temporarily. Like you're going to sit in for this hearing. That's it. You don't stay on the board. You are here temporarily because McBurney had to recuse because it's his nephew.
So I'd love to say that I did. These guidelines are relatively recent, so there aren't a prime example of that occurring just yet. In addition, part of some of the questions that we have to adduce in evidence are, were you provided with these guidelines in advance when you were onboarded, for example, as a new board member?
Okay.
Yeah.
So your argument is that the policy says it says you shall recuse, and recusal is not abstention. Recusal would mean you're not even in the mix. And so if Ms. McCoy is saying, I've got a conflict, she's not complying with the policy if she merely abstains. Words mean something. She should recuse, which means she's not present at all, in which case you don't have a full board. You have 4. Setting aside whether Mr. Bennett has a conflict as well, you're already at a point where, contrary to the Constitution, the full board's not hearing the application.
Your Honor, you're making my argument for me, but yes.
I just want to make sure I understand it.
That is right. That's absolutely right.
So,
and if I may add, it's slightly different from the argument in respondent's brief, where they're using quorum to justify that they don't need to have all 5 members, and that's a different component of this.
Okay, are you going to get to that? Because
yes.
Okay,
yes. All right. So part of the respondent tries to sort of use, if there are 3 out of 5 board members that are available and can preside over this, then you've reached the amount that you needed and will be fine. But that is simply the amount you need for quorum to be able for that clemency proceeding to go forward. It is not what is required, and it's certainly not what Fugate has stated. It doesn't negate the requirement, and this is straight from Fugate, which is in the next sentence that they left out of their brief. It does not negate the requirement of 5 appointed board members of the board at all times, who are to have an opportunity as required by the Constitution to consider applications for themselves.
This quorum, 3 out of 5 would be a quorum. Are there rules that talk about the board conducting business with a quorum, or is the quorum?
Josh just gave me the lowdown on this case.
I think of quorum as we now have enough people in the room to conduct business.
Let me pause.
And if there are any rules that talk about there being...
We're going to pause Judge McBurney really quickly. This Humphreys guy, he was a bad dude. He executed 2 women in their office, strangulation, a whole bunch, stole their IDs, left them basically bound, shot, naked in their office, and then stole money from their ATMs, was on the run, was caught in Wisconsin. There's a reason he's on death row, okay? But they're arguing here to stop this procedure.
A quorum, it would seem to be unnecessary. If the Constitution says you have to have everyone there, then your quorum is everyone. It's not 3, it's not 4. Where does the notion of quorum come from in terms of the operations of the board?
Sure.
I know it's in the respondent's brief. I got that, I don't remember if they cite to, Rule 1.101 says a quorum is enough. 3, you can go forward.
So in the, I believe it is later in, one of my colleagues may bring this up to me, but
I don't believe he's present in this one. I don't think he's in court. These are just his attorneys.
I know there is a section about as long as you've got 3 out of 5 members to.
While you're looking, let me ask
forward.
Ms. Niles a quick question.
Great.
He's a bad dude. I just read. I mean, obviously, I'm not going to read the full thing. Josh gave me a book on this. It was Josh, right? Yeah, Josh. Thank you. He's scheduled to be executed on Tuesday.
Not a thing.
Between Tuesday and the 24th, Christmas Eve.
Oh, he has cases from that.
They're arguing about the board clemency hearing that legally has to occur right before they execute him.
I just want to make sure.
And one of the
he's not,
board
like,
members
there's this bus
is
stop or something bad.
connected to this case, I believe, to one of the victims. So she has to abstain. They're saying because she abstains, the whole board doesn't hear it, which the law requires the whole board to hear it. Thus, it doesn't count as a clemency hearing, so you have to commute his sentence because you can't kill him.
I'm ready when you are.
Thank you.
Wow. And yes, a lot of attorneys on the death row side, you see all of them there. You got a whole team of 5 people fighting this. There are lots of attorneys that hate the crime, but also are against the death penalty and will fight to make sure the death penalty does not happen, even if that's a technicality in every case. Yeah, Christmas Eve, you'd think they would do it before then, right?
So
I did show his
the
picture just a
quorum-
minute ago.
So the quorum, it requires a quorum of a 5-member board to act, which is, I believe, the 3 out of 5 members to grant the clemency petition.
Okay. To act as in 3 have to vote for it, or they need 3 in the room to do it?
You need 3 to vote for it.
I didn't say that well. You just repeated me, so I'm the one who didn't say it well.
apologize.
No. But there need to be 3 votes in favor of X for X to occur with the board, not that 3 people have to cast a vote, so that a 2-to-1 vote would actually carry the day. You see the difference between the two?
That's right. So under the Georgia Constitution, you have to have, you can't, for example, if there are, let's say, just 4 people, it can't be a 2-to-2.
That would be a tie.
That would be a tie.
Right.
You can't have 2-to-2. It would have to be, for example, it always has to be at least 3 voting in favor of clemency.
So an
it has to be
abstention
3 to
lowers your
5,
odds of
3 out of the
getting
5
clemency.
voting for that.
But what you read to me sounds like you could just have 3 people in the room, and if they vote unanimously, that's 3 votes, and that carries the day. And if you had 3 people in the room, 2-to-1 wouldn't work because that's
wouldn't.
not 3.
Correct.
Okay.
It has to be at least 3 in favor of clemency.
Okay. All right. I'm ready.
Okay.
This is probably one of the heaviest hearings a court has to hear. It's basically the last court date before execution. And Judge McBurney is a great judge for it. He's listening to all the arguments.
Yes. Okay. It's attached to our pleading, right? Is it attached to our pleading?
Yes, it is.
Okay.
It's number 14. It's exhibit 11.
Okay. So Exhibit 11 attached to our pleading is the fugate order that has the discussion at page.
I don't know when he was sentenced. Well, I can tell you, actually.
I think it's page 5. About needing the fully constituted board members.
This was back in 2003 it happened, so he's probably been in jail since at least 2026.
Respondent's suggestion that the quorum rule anticipates a board vacancy does not square with the Constitution's mandate that the full board consider clemency applications.
He's obese and has requested a large last meal. Josh brings us the heavy cases, and I'm promoting Festivus. Okay. Josh, thank you. I think you sent me a link for his criminal history. Let's see.
So the quorum rules, OCGA 4297.
You just sent me to a search page, Josh.
Quorum rules are established by OCGA 4297. And that was the same issue that came up in Fugate, where again, the respondents there attempted to argue that the statutory rights were not violated by having 4 board members presiding over the clemency hearing, which constitutes a quorum, because the quorum was established by 4297. The court held in Fugate that construing constitutional and statutory provisions together, the quorum rules are applied to determine just the necessary number of presiding board members, given the constitutional requirement for a fully constituted board, which is 5 members. And that although only 3 of the board members need to preside over a hearing to constitute a proper quorum, this does not negate the requirement of 5 appointed members of the board at all times who are to have the opportunity as required by the Constitution to consider applications for themselves. And it goes on to say quorum rules were established by the legislature. The people of the state of Georgia voted on the constitutional guarantee of 5 members of the board of pardons and paroles. Hence, in order to respect citizens' expectations, the court must strictly construe a constitutional guarantee of 5 board members, especially in light of the possible irreparable harm to the defendant.
So I guess we've sort of come full circle.
We're coming full circle.
The Constitution in Article 4, Section 2 says that the full board, not a quorum, the full board, to me that says all 5, shall have an opportunity to hear the application.
They have an opportunity.
But if Ms. McCoy's sitting in there, she's hearing it. I guess your argument is to what end if she's not going to vote? That is honoring the word of the Constitution, but not the spirit of the Constitution. She doesn't have the ability, if in her heart the vote is X, to cast that vote if she's abstaining.
Correct.
Okay.
It has to be 5 board members. Has to follow the Constitution, and you can't escape that by using 4297.
Okay.
And she can't abstain. She has to recuse, and there has to be a new board member.
What about Mr. Bennett?
Mr. Bennett.
And I guess I should be clearer. What I mean specifically is help me understand why then Sheriff Bennett, doing his job, apparently doing it well, the trial went off and there didn't seem to have been security issues there, conflicts him out of being a participant in the clemency hearing.
So part of a large chunk of the clemency process will focus on the juror deliberations at the penalty phase.
It's people pounding on the wall and crying, and there was actual hole in the wall.
Correct. And
Whoa.
Mr. Bennett was in fact present and around the jurors during that process, which our contention, and we would like to adduce evidence from him regarding some of that, because it makes him privy to more of that, not just more of that information, but also the emotions that run high during that period of time. Penalty phases are incredibly difficult times of trial.
And this trial went as in Georgia death penalty trials should, same jury deciding penalty. They didn't bring in a different jury. So the jurors who found Mr. Humphreys guilty then labored through the sentencing phase. And so jurors who are getting emotional in the deliberation room are the same ones who found him guilty. Okay.
They punched holes in the walls during deliberation?
All right.
This is nuts.
And he also had personal interaction with Mr. Humphreys as well, obviously prisoner transport, other courtroom interactions.
Okay, so you would like to elicit some evidence from Mr. Bennett?
Correct.
Okay. Ms. Piper, any issue with that? I know, I think it was Ms. Crowder maybe who reached out. Someone from your team reached out via email. And I said Zoom participation's fine if people are far away. It seems like there is a factual component on Mr. Bennett's side to this, what we need to, as a group, evaluate on the conflict piece. This has nothing to do with quorum and abstain and whatnot. You'll get an opportunity to respond to all of that. But I'd like to hear a little bit more about his connection to the trial and even what he remembers about it.
We anticipated that you would.
Okay.
We have absolutely no objection to him talking about his lack of personal involvement.
Okay. I don't want you to coach the witness. Mr. Bennett, I see your name on the screen. Are you able to have your camera turn on and your microphone?
Here comes the sheriff looking at this guy's rap sheet.
Yes, Your Honor.
Burglary, theft by taking, burglary, entering vehicle, forgery, burglary, entering vehicle, possession of firearm by a convicted felon, theft by receiving stolen property.
All right, so
impersonating another, murder.
I can hear you, but you're a black box,
firearm,
so we'll need to figure out how to get that camera to work.
Murder, kidnapping, aggravated assault. The defendant has, he's got a few pages. Criminal history goes back to 1993. I'm sure the juror was acting out because of the missed lunch order. Why was he out? This is a great question. I mean, there's a judge that sort of has to answer this question in their heart. Why did I grant this guy?
Do you all have any technically trained agents near Mr. Bennett?
Just take the tape off the camera, Mr. Bennett. That'll help.
I saw them. What is
this? Just misunderstood.
It's full-blown warrants. Okay.
The irony of the sheriff being in the dark, not lost on me here.
Mr. Bennett, you gonna be
Yes,
able?
sir.
We don't have any video from you.
The video button, maybe?
Have you tried pushing the video button? Helpful comments from the peanut gallery. Have you tried turning your camera on? No, he knows where the button is. He just needs to find his shirt. You know those officers that what was it in Chicago? The officer that testified without any pants on.
Let me try this. No.
Mr. Bennett, can you see us on your screen?
Yes, I can.
All right. Do you have a screen that has a camera?
In the past, it worked okay, but it's apparently not functioning correctly right now.
Go out and come back in.
Did you perhaps maybe accidentally turn the camera off? Hit a button or something at the top? Or swipe the top of the laptop?
Is it working now?
Oops. I just hit the wrong button. Try one more time.
Paging Mr. Bennett. Paging Mr. Bennett.
Nope, you're still a black box. You don't happen to have any kids in the house? They're the ones who always make this work for me.
You're exactly right. I wish I had a grandchild here with me right now. We wouldn't have any issues.
Perhaps you could get him on his phone.
Yeah, I don't know. Some people, when they get stuck like this, they'll dial in on a separate device, one for audio and one for video.
It's like, I don't know how to do that either.
Can you do that, Mr. Bennett?
Yes, I'm going to try to call my office to speak with IT.
Okay.
Is that okay?
We'll be here all day. IT's on
So
lunch
we're going
break.
to take a quick break. I have 2 search warrants. I'm going to quickly peruse for Investigator Wilson. All right, let me peruse these and then we'll get you up here.
Judge McBurney looks over the search warrants.
Off the record?
Yes, ma'am.
Thank you.
Okay.
Okay, someone needs to send me all these appearances. Y'all said y'all were going to email them to me. When people speak, I need to identify them as we're going along.
I ain't
All
got
right, Ms.
jack.
Karen Shack put something in the text saying she did just that.
Open up your chat.
Those are the 3 lawyers whose names you got are all colleagues of Ms. Karen Shack's. She said she sent you an email.
I do. A 8D defendant, SCA 8D prosecutor. I see Miss Piper, but I see somebody sitting next to her. So if y'all could just email me all your team members, somebody for the defendant or respondent, however you want to be identified. And I do have the email from Zara, but I just need everybody that's at the council table.
Ms. Nichols, can we get your email address, please?
Yes, I'll paste it again in chat. And it is, hold on just a second. It's Laura, L-A.
It's bestreporter@gmail.com. Just kidding. We're just making those up. That's probably somebody's email, but.
.net.
.net.
And can I ask who ordered the court reporter? Do y'all need a transcript expedited? I just need to know what to expect so I can have a team working.
Sheriff's here.
Okay, there's Mr. Bennett.
We ordered it. This is Tita Piper with the Attorney General, and yes, we would like that.
Expedited.
Oh, Zach ordered it. We'll share. We'll share.
Okay, so y'all are splitting the cost of the court reporter and both want an expedited transcript. Is that correct?
Yes, ma'am.
Mr. Greenemeyer, is that correct?
Yes, it is.
Okay, thank you.
Ooh, Mr. Bennett wearing the mint green tie today.
Sorry, I didn't get through it before we got our share. Are you good for a little while longer? You good? Okay, you can watch this hearing. All right, Mr. Bennett, how are you doing?
I think we are ready to go, Your Honor.
Great. Thank you for finding a grandkid to make it work. All right, I'm going to have the deputy swear you in, and then I think we're pivoting with lawyers because Ms. Sino said she doesn't do evidence, she does argument. All right, but first, if you'll raise your right hand.
Raise your right hand. Do you swear or affirm the testimony you shall give to the court today will be the truth, the whole truth, and nothing but the truth, so help you?
I do.
Okay, you may lower your hand. Please state and spell your full name for the courts.
Yes, my name is Wayne Vernon Bennett. It's WayneVernon
Thank you.
And from where are you joining us, Mr. Bennett?
St. Simons Island, Georgia.
Wow, we should have had court with you. That's what we should have done. I'll come join you. All right, we appreciate you making time for this. Counsel?
And does the court mind if I sit so I can?
As long as the court reporter can hear you, I'm good.
All right. And Mr. Bennett, can you hear me okay?
I can.
All right, beautiful. You are currently the vice chair of the State Board of Pardons and Parole, correct?
That is correct.
And you come into this role after a long and varied and successful career in law enforcement?
Yes, sir.
All right, and I want to show you just for the record what I believe is your bio. Can you see that?
No. Yes. Not the best picture, but how many pages is it?
First off, Mr.
Three
Bennett,
pages.
can you just see what's on the screen? This document.
I can.
Okay. All right. And I can scroll as quickly or as slowly as you would like. But does this appear to be your bio on the State Board of Pardons and Parole website?
Yes, sir, it is.
Okay. And this details some of your accomplishments as a law enforcement officer, including as a sheriff. Correct?
That's correct.
All right. And then we would move to admit this as Plaintiff's Exhibit 22.
So do you have copies to give to respondents, and do you have an exhibit list? Because 22, I have exhibits 1 through 14 that were part of one of your pleadings, but I think they were really appendices. Oh, look at this. Never mind. Binder. All right. Exhibit 22.
Binder's quite exhibity.
And Ms. Piper, are you handling this part of the proceedings as well?
No objection.
No objection. 22 is admitted.
Thank you, Mr. Bennett. And getting into it, you were the sheriff of Glynn County throughout the 2007 trial of Mr. State v. Humphreys, correct?
That's correct.
And as we just alluded to, the trial was not held in Cobb County where the offenses occurred, but instead in your county, in your sheriff's office, correct?
That's correct.
And your office had a number of roles in facilitating this trial, correct?
That is correct.
You were responsible for courthouse security?
Yeah, it come under the direction of my office.
Correct. And your office was responsible for housing Mr. Humphreys at the jail, right?
That is correct.
And your office was responsible for transporting Mr. Humphreys to and from court each and every day of a long trial, correct?
Yes, sir.
In addition, I understand that there were a couple of extra roles for the sheriff's office due to the nature of this case. In this instance, the jury was sequestered, right?
That is correct.
And the sheriff's office coordinated security at the hotel for the jurors, right?
Yes, sir.
And they arranged for that housing for the jury for the over a month the trial was going on?
That is correct.
1 month sequestration.
They arranged for the jury's meals.
Now I know why they punch the walls.
Yes, sir.
And they took precautions with regard to the television, newspapers, visitors, telephone calls that these jurors had, right?
Well, as common practice, we would confer with the presiding judge to get the stipulations that he or she would place on the jurors, and we would abide by those rules.
And in fact, in this instance, jurors were instructed or encouraged, or somehow they monitored, to not inadvertently gain access to information from the media, newspaper, and television. Correct?
Yeah, that would be correct.
And the sheriff's office was responsible for either limiting or screening visitors to the jurors during their sequestration?
Normally, visitors aren't allowed. In some cases, they are allowed to talk with their families by telephone. And I do not recall exactly what the stipulations were placed on that particular jury.
Okay. Now, I may be able to show you some documents to refresh your recollection, but does it sound right to you that the jurors were limited to phone calls of 5 minutes of duration that were in the presence of the sheriff's office personnel during the course of this trial?
Correct. That's correct. That's usually the normal procedure.
Okay. All right, I want to show you another exhibit, which is Exhibit 7, which is in our petition. And can you see this?
It's from 2007. It's got it's the sheriff's letterhead, right? Or the judge to the sheriff.
I can see. I would actually need to
transport
enlarge
order.
it just a little bit.
Yes, sir. And please aggressively instruct me to make it bigger, go up, go down, whatever you need. Okay. So you can see this right.
This attorney likes aggressive instructions.
Okay, it's pretty clear now.
Okay. And let me know if you want to read more of the first page before I go on to the second page.
Okay, it's, I'm not really familiar with that correspondence as it would have gone to my courthouse staff, which I believe at the time was Major John Scott.
Okay. And but you would agree that this letter is addressed to you, correct?
That's correct.
And it outlines some of the sharing of responsibilities between the Cobb deputies and the Glenn Sheriff's Office deputies in the course of this trial, correct?
That's correct.
All right. And we would move to admit Exhibit 7.
Any objection to Petitioner 7?
No objection.
Right. And I want to show you another letter.
This dude was a bad dude. I mean, I summarized the crimes, but.
All right. Can you see this document? Not yet, I guess. All right. So this appears to me to be a October 4th, 2007 letter from you to, it appears, and correct me if I'm wrong, that you wrote to each of the jurors in this case.
Yes, that's a standard form letter that we send out to the jurors in all of our jury cases that helps us evaluate our job performance and things that we could do in the future to make their stay a little bit more comfortable, especially with the sequestered jurors.
I would like to personally express to you my sincere
to get their
appreciation.
input
That's
as
a form letter?
What could be made better in our policy.
Okay. And we would move to admit Exhibit 8.
Any objection to Petitioner's 8? And Mr. Bennett, you're saying this letter, while it's customized to this trial, was fairly typical outreach from your office to jurors? Because it looks like it's, other than explaining a few things to jurors once their service is complete, you're looking for feedback. What could we do better next time so that the experience goes a little better for you, the juror?
Yes, as an organization, we're always looking for ways to improve our services to the people that we represent. And this is a tool that we use to try to meet those requirements.
And
I'm sorry, is that exhibit received in evidence?
Yes, it is. Mr. Bennett, would you say that this is typical to send out a letter like this, or it would just be in the longer trials, or what percentage of the cases for which your team provided juror security and whatnot would you send out a letter like this?
Only sequestration ones.
Well, anytime that we had a sitting jury, we would send out letters very much similar to this one.
When you say a sitting jury, meaning a jury that heard a trial, not sequestered, but any trial?
Actually, when they actually heard a trial.
Okay, thank you.
Okay.
But the letter says
go.
we've arranged for housing, meals. This is a sequestered letter.
So I see in this letter some set of customization or tailoring to the facts here. I would imagine not every jury in Glenn County is sequestered, correct?
I'm sorry, did you say every jury is sequestered in Glenn County?
I would say I imagine that's not the case, right?
Oh, that's not the case, no.
Right. And looking in the
third paragraph,
last, I guess, full paragraph, right? It says, for you as a juror, it has been difficult being separated from your daily routine with your family and friends. You continue, however, you and your fellow jurors have been an exemplary group to work with. Is that standardized language that you include in every letter, or was that tailored to the unique circumstances presented by this jury?
I would say it's pretty much standard wording. However, there is time to time that there are some issues that would come up during the trials.
Okay.
We've arranged your housing, meals, and everything else.
Okay. Setting aside the the correspondence with the jury, but fair to say from the perspective of the Glynn County Sheriff's Office, this was a significant and complicated undertaking for the Sheriff's Office to, in addition to the day-to-day responsibilities of conducting a jury trial, to deal with the unique circumstances presented by a sequestered jury. Would that be fair?
I'm going to object. Counsel's testifying. There's not a question in there.
Would that
a lot
be
of
fair?
testimony.
So, technically you have this person kind of on direct examination. I appreciate you wanting to get through all this, but you should ask him what he remembers, what his connection was, et cetera.
And Your Honor, if it's possible, we would like to, this is a party opponent, to treat this as cross
hostile witness.
Okay, no, fair enough. I'm thinking about who is suing whom. So, okay.
So they get hostile witness. They can lead now.
All right. So the question was just, would you agree with me that this is a significant and complicated undertaking for the Sheriff's Office that wasn't presented by your day-to-day administration of the jail and the...
Meaning managing the sequestered jury for a month-long trial?
Correct.
Okay.
It takes a considerable amount of more planning in doing a sequestered juror, but it's not beyond our ability to make sure everything goes smoothly and the needs of the jurors are met, and keeping the presiding judge informed as to any abnormalities in the jury room that we may be aware of. But at the time we were quite familiar with sequestered juries as well as death penalty cases.
Yes, sir. All right. A couple questions about Mr. Humphreys at the jail for his stay in Glynn County. Before he got there, did you speak with the Cobb County Sheriff about Mr. Humphreys?
I'm sure that I would have had a conversation with the judge, the sheriff, and as well as the undersheriff, because I personally knew them, to find out if there's any particular needs of this inmate and just get an overall view of what to expect from him or family members, which is routine to do.
Okay. And what about with Judge Robinson, who wrote the letter that we looked at earlier to you in Exhibit 7? Did you ever talk with her about Mr. Humphreys?
The best I recall, it was very brief when she arrived at our courthouse. I can't say verbatim what our discussion was, but I was inquiring about any special needs of her court as to how I need to perform, or my employees had to perform during the duration of this trial.
And were you involved in designating the security classification or any specific, changes to standard security procedure for Mr. Humphreys while he was in your detention center?
We had a written protocol policy that would define how the inmate would be transported, would be handled, and if there were any special instruction from the court or from the sheriff in Cobb County, and the appropriate employees would take charge of that.
Okay. And do you recall any departures from standard policy and procedure that were put in place for Mr. Humphrey specifically?
No, I don't.
Did you receive any information or come to any conclusions about whether Mr. Humphreys posed a particular flight risk while, or either before or while he was in your custody?
Ladybug's mom, thank you very much.
No, our facility, it was a maximum security facility. My deputies and detention officers are well trained, and I had all the confidence that any situation that would arise, that they could handle it properly and efficiently and professionally.
And if there were any departures from standard policy or procedure, would that be something that ultimately would be for your approval?
I would be made aware of any situations out of the norm, and we would discuss it, of course, and take appropriate action.
For those that asked about the haptic vest, it's a Bluetooth connection. You just install the app on the MetaQuest, and then it pairs with the device.
All right, so I want to show you.
Sure.
Maybe approach
something not in the binder.
This is something that's not in the binder. Okay, and this is a packet of 46 pages that were received from the Glynn County Sheriff's Office about Mr. Humphrey's time there. And I got a couple questions about it.
Skipping down to page 70, 80.
I'm going to object until there's a foundation laid that he has any knowledge about these documents he's being asked about.
Okay. Well, they haven't been tendered yet, but sounds like you're going to need to lay a foundation if you want to tender them. You may be using these to refresh his recollection. I'm not sure, but proceed accordingly.
Mail office.
Do you see what's on this page right now, which is page 38 of the PDF?
Allie B, I'm so sorry.
I see the instructions from the initial agency to our office as to the history of the inmate.
Okay. And this is your understanding that this is something that came from Cobb County to Glynn County, but not something that Glynn County generated. Is that right?
That's correct.
Okay. Do y'all have this has been a number of years, but it says he will be housed into, it looks like DR 112. Did y'all have a cell DR 112?
Well, at the time we did. The actual facility no longer exists, but it was where we kept people in cells. They were cells made for the individual, not to general population.
Okay. And you would agree that this document says that must exercise extreme caution with Mr. Humphrey, correct?
That's the notation in the memo.
And later refers to him as extremely dangerous.
Yes, when you're handling a death penalty case, most of the verbiage in these memorandums of understanding with the inmate is pretty standard.
Okay. And then I want to show you on the page before that, this looks like an email involving Mr. Corbett, the undersheriff that you referenced earlier.
That's correct.
And in addition, you see here that he refers to Mr. Humphreys as very large in stature.
Yes.
Okay. And I want to go to the last page on here. This looks like a Glenn County Detention Center medical administration record. I don't have any questions about the medicine here, but I do have a question about this notification here. It says no female contact at all. How did that come to be made part of his medical record?
I really do not have a definite answer for that, but considering the charges against the inmate, precautions would have to be taken to ensure the safety not only of Mr. Humphreys, but my employees as well.
And you would agree that just where it lists where Mr. Humphreys is assigned, it's DR 112. Do you see that?
Yes, I do.
Okay.
Was there a question to that, please?
No, sorry, I apologize. I was conferring with counsel. All right, so what conversations do you recall having with Mr. Humphreys?
I would say absolutely none. At that particular time, we were housing in the excess of 400 inmates. I had very little one-on-one contact with the inmates, especially the inmates that were in a high custody unit.
Mr. Bennett, I'm going to pop in here for a second just so I can get some perspective. I'm familiar with a very, very large sheriff's office being here in Fulton. And I know just from having had productive conversations with our sheriff that his organization is so large, and necessarily so, that his answer to a question of did you ever have a conversation with an inmate would be invariably no, because I'm making the number up, a 500-person business. And if I go to the jail, it's to meet with the jailer and the top command, but I'm not interacting with inmates in the courthouse. I'm not interacting with them in transit. I'm not interacting with them in the jail. Glenn County is smaller, but it's not teeny. And so I'm wondering, in the ordinary course of the work you did for the 30 years you were sheriff, if 20 years you were sheriff, if you routinely had conversations with inmates.
Oh, I would have conversations with inmates from time to time, but they were in the lower security units. I was always accompanied by staff, but the ones that are in the high security units, and I think we had approximately 32 individual cells where they were very restricted on the time outside the cell, which was only 1 hour per day for exercise and just to be able to be outside of the cell and to shower. So my time going through that unit was very small, except for more or less to inspect the area as far as physical condition.
Would you ever have been one of the individuals directly, personally involved with transporting Mr. Humphreys from your jail to the courthouse and back?
No, sir, not at all.
And when Mr. Humphreys was in the courthouse for his trial, would you have been regularly interacting with him? Just checking on you, Mr. Humphreys, want to make sure you're okay?
No, sir, I would not.
So if you had to guesstimate on fingers the number of conversations you had with Mr. Humphreys, can you fit it on one hand? Is it two hands? Do we need to get to toes?
I would say absolutely zero.
Okay. What about members of Ms. Williams or Ms. Brown's family? Those are our two victims. Would you have interacted with those families very regularly?
No, sir, not at all.
Okay.
Even though we're small, that courthouse, there were still regular activity in the courtrooms, which we have 3 superior courts on that floor where Mr. Humphreys was being tried, and those courtrooms were filled on a daily basis, and the public was in the rotunda and going throughout the courtrooms and the grand jury rooms and what have you.
Okay, thank you.
Was it the case that when Mr. Humphrey's trial was going on, are you saying that there was court happening in the neighboring courtrooms, or was when Mr. Humphrey's trial was going on, that was the only business being conducted in the court that day?
No, there was other courts in session. They're all individual courtrooms.
Okay. And how often would you set foot in the courtroom where Mr. Humphrey's trial was taking place during the course of that trial? Would that be an everyday thing, a never thing, in between?
I really couldn't put a number on it. If I went into the courtroom during Mr. Humphrey's trial, probably less than 5 times.
You were, or your office was responsible not just for housing Mr. Humphreys, but also for making sure he had haircuts and clean court clothes and the like?
Usually the request for haircuts and personal hygiene issues, the clothing, anything else, usually came from the attorneys.
Okay, but your office would be responsible for making sure that those attorneys' requests, provided they were reasonable, were made happen.
Yes, we were self-contained. We had barbers, doctors, psychologists, psychiatrists. We were a city within a city.
And during this process, even if you're not having conversations with Mr. Humphreys, were you able to observe, were you able to see him throughout the course of the trial and, the time that he was at the jail?
I don't recall seeing him. I testified earlier, we had 400 plus inmates in our custody, and I had a lot of responsibilities for the whole facility, as well as my responsibilities outside in the unincorporated areas of Glenn County.
So you wouldn't be able to see his affect or his emotions when he was at in the custody of Glenn County, either when he was at the jail or he was in the courtroom. Is that what you're saying?
Could you repeat that question, please?
Yeah. Were you able to just observe his affect or his emotions throughout the weeks that he was present with you or with your office during the course of the trial?
Not as I recall, but if I did, it was any sighting of him was unremarkable to me.
Okay. You have no recollection specifically?
No, I do not.
Defense is trying to get the sheriff excluded so he can't testify to the board.
Talk a little bit about your office's dealings with the jurors. So we talked about sequestration and some of the issues there. I got a couple questions about the meals. So I would imagine your office is for some meals bringing food to the jurors?
We would cater inside. It depended on the presiding judge. If they wanted to have lunch at the courthouse or if they wanted to have dinner at the courthouse, that was handled on a daily basis. We also would transport the jurors to restaurants in our community.
Okay. Just about my next question.
You might be a city member.
Did you ever share a meal with the jurors during this process?
No.
And, in reference to the judge's, questions earlier, Glenn County is not Fulton County, but it's also not a small county. I imagine you as the elected sheriff might have had some familiarity with some of the jurors before their service. Do you recall whether you knew any of these jurors?
The information that I've been reading for the past month I saw the names, but I'm not familiar with any of the jurors.
Okay, so you've seen the list of the jurors at some point in the last month, and you're saying that you don't recognize any of those folks.
That's correct.
Okay. And during the course of their sequestration, we talked in that letter about taking precautions with newspapers, televisions, visitors, phone calls. I imagine sometimes that might be frustrating for the jurors to have their lives interrupted in that way. Did you ever have any conversations with those jurors about those frustrations and just how to manage them or why all these rules were in place?
I personally did not have any interaction with the jurors. My staff would have been exposed to any questions or requests by the jurors, and if they were not already agreed upon with the presiding judge, then it would be forwarded to the judge to get guidance on how they would like to accommodate the jurors.
Okay, and then would your people then report that to you, what was going on with the jurors during this time?
No, I had full confidence in their ability to do their job professionally in the way they were trained to do it.
You're right. Wayne Bennett is one of the 5 on the board right now.
For security in the courtroom, you testified you may have been in the courtroom for 5 or so days during the course of the trial. Does that sound right?
That's a misstatement of evidence.
Excuse me, Mr. Bennett, if I didn't recall correctly, how many times would you say you estimated that you were in the courtroom where
less than 5.
Mr. Humphreys was being tried?
I really can't give a positive number. If I think I stated I may have been in the courthouse maybe 5 times during the time period. I really do not know. I have business with the judges, the DA's office, in the jail from time to time, and my times at the courthouse would be inclusive in that number 5 if that was during that time period.
And at some point, I understand that deliberations amongst the jurors got heated. My question to you is, how did you become aware of that?
I probably late in the afternoon when when the court was in recess, but it's not unusual for the jurors to have disagreements, the jurors to become vocal. When you're away from your family and you're living with 14 other people, 12 jurors and 2 alternates, when you start exceeding 3 days, it gets a little tense, but it's human nature, and we deal with it accordingly. And the judge is always made fully aware of the issues going on.
Yeah, and help us understand that a little bit. So I understand, you mentioned tension. I understand that. I understand here there's instances of screaming and crying in the record. Were you aware that the tension escalated to that point of where jurors were audibly screaming and crying?
I don't recall on this particular case. It has been brought to my attention in other cases, but it becomes pretty much routine after you've been in this business as long as I had, and you know how to deal with it, and you take the precautions and you try to find the remedies to bring everyone back in line and to proceed with their assigned task.
And yeah, talk us through a little bit about, based on your extensive experience, how your people or you yourself would support jurors or make sure that, things weren't crossing a line in the course of that, tense deliberation.
Well, that actually would be under the guidance of the presiding judge. Normally the jurors would be returned to the jury box, and the the judge would address the situation.
Okay. In this instance, I guess at some point a juror threw a punch that connected with the wall of the jury room. How did you hear about that?
I really didn't hear about it until I read it in the lawsuit in the past few weeks.
Okay. So depending on the circumstances, throwing a punch that damages government property, that could be potentially a criminal offense, right?
I'm not sure a punch was actually thrown. I have not seen or had any direct testimony to say that that happened.
So that's my next question. Did you or any of your people investigate what was going on inside that jury room, at least as far as potential act of violence?
If it was determined that there was an act of violence and someone was hurt or there was a violation of state law, it initially would be brought to the judge's attention, and then we would proceed from there.
Do you know who made the repair to that wall? Was that something that the sheriff's office personnel would have done, or is that something that the court would have done? Court personnel.
I'm going to object. He's already stated he was unaware of a hole in the wall in this trial, and you're asking who repaired it.
Let's stay focused on Mr. Bennett's potential connection to Mr. Humphrey's trial, Mr. Humphreys, the victims' families, the jurors.
Were you, Mr. Bennett, aware of what the source of the strife within the jury deliberations was? Were you aware that it concerned whether it belonged to a particular juror, or whether it about their position, or whether it had something to do with food or family? Did you know anything about that?
Could I ask you to repeat that question, please?
Yes, sir. And I apologize for asking a poor question. Were you aware of the source of the strife within the deliberations? Was it a particular, did you know whether it was a particular juror or not?
We do not get involved with the deliberations of the jurors. Our job, of course, is to secure and protect the jurors and have them at places where they need to be. We do not get involved in deliberations or anything outside of our scopes unless it's asked of us by the presiding judge.
And just to be clear on this, if there was in fact the hole in the wall, would you generally expect to have been made aware of that as the person ultimately in charge of courtroom security?
Well, the hole was actually made in the wall is strictly cosmetic, and the trial is more important for us to control, and we can fix that hole in that wall at a later date.
But if there was a punch thrown that damaged the courtroom wall, would you generally expect to have learned that information during the trial?
If it in fact happened, I would assume that I would have been made aware of it by the staff, and the staff would have been directed to confer with the judge for information, and the judge would advise us one way or the other as to they would like for us to proceed.
Understood. And again, just to be totally clear, your testimony is you do not have any recollection of receiving that report at the time, right?
I do not.
Okay.
I think they're not going to get him kicked off.
Bennett, thank you for your patience. I want to come back to that letter.
He's sitting in jail.
This is Exhibit 8.
Prison.
And in the last bit, it says, if I or any of my staff can ever be of assistance to you, please do not hesitate to call.
Did they ever call?
Did any of the jurors call you or ask for assistance in the future?
No, they have not.
Okay. And
not that I recall.
Sure. And did you get any responses back to the survey in this instance?
As a general rule, with all the letters we send out to the jurors, we get a very good response back, and it's mostly constructive criticism. We do get complaints about the meals, of course, and other things that we really don't have any control over. But it is used as a constructive tool for us.
And I understand that as a general.
We try to direct them as to where they can get an answer to the question.
Understood. And I understand that to be as a general matter. Do you have any specific recollection, one way or the other, of whether you received survey responses from the jurors in Mr. Humphrey's trial?
I do not. It's been quite some time since that trial, and I would have to go back and pull those records to see if they even exist.
And would you be willing to share those with us if they do in fact exist? Or share them with your counsel at least.
If I'm directed by the courts, I will be glad to share it with you.
Oh, so directed.
And so I understand your, from your earlier testimony, it appears that you may have reviewed or at least received Mr. Humphrey's clemency petition already. Is that true?
I have.
Okay. And I asked a bad question. I asked whether you had received and reviewed it. Have you both received it and reviewed it?
I have received it, and I have been making myself aware of the case through the transcripts, the statements from the jurors, the doctors, other attorneys. It's quite large in volume, and it's taken a little time to do, but it's going to be accomplished by hearing date.
When is the hearing date?
Possibly.
I have no clue.
Thought I'd try.
And I appreciate your thoughtful review of that.
Scheduled for tomorrow.
As you may be aware at this point, one of the big issues in the clemency application is Humphrey's team says there was a hole in the wall, and maybe the other side is going to say there wasn't a hole in the wall. Would you agree that you are in a position to know facts about that question that is not the same as the other members of the board?
Your question is not, does he know them now, but he has the ability to learn more about it?
The question is, do you, Mr. Bennett, have more information that might help answer that question from your role in 2007 in the courthouse as compared to the members of the Board of Pardons and Parole who were not in the courthouse in Glynn County in 2007?
And I'm gonna object because he's already asked and answered about his knowledge of the whole.
Right. Next question. While you're thinking of your next question, Mr. Bennett, when you received the clemency application from Mr. Humphreys' lawyers, and all you knew when you first got it is it says Stacey Humphreys, did that name mean anything to you, or was it not until you got into the file and, oh, wait, I was here for that case?
Well, Your Honor, I actually had prior knowledge just maybe a few weeks that this situation was coming up before the board. And when I saw his name, I recognized his name. But prior to that, if you would have asked me about a trial from Cobb County, I would have had to look at documents to become familiar with it.
Okay.
And Mr. Bennett, we've looked at, and I can show you again, the ethical rules for the Board of Pardon and Parole. Do you receive these as part of your onboarding when you came onto this board in 2024?
was educated from the day that I came on board to this very day today as to policies and procedures. And it's like any other profession, it changes and you need to be kept up to date. And I feel like have been well versed on the procedures of the board.
Okay. And you would agree that as part of your role, it is important to be free from any conflicts of interest, correct?
That's correct.
As well as free from any outside influences, which could influence your ability to perform your duties.
Yeah, I perform my duties because I deal with facts and evidence, and to be. My mission is to be fair, honest, but firm, and I take all those factors into consideration in making any decision.
And how many death cases, death penalty cases, occurred while you were sheriff of Glynn County for the 20-year tenure?
Well, when I was actually a Glynn County policeman, I was directly involved with death penalty cases where I was involved in the investigation, or I oversaw the investigation as the commander of the Criminal Investigative Division. As sheriff, I recall at least 3 death penalty cases, and all 3 of those were change of venue cases. They were brought to our county to be tried.
Do you recall the names of the people who were on trial in those 3 cases, besides Mr. Humphreys?
Object relevancy.
Stop for 1 second. Response?
I did not recall any of the names.
Hold on, Mr. Bennett.
Stop.
I'll withdraw the question.
Okay.
Yep.
All right.
His last meal: barbecue beef brisket, pork ribs, bacon, double cheeseburger, French
You
fries.
testified
coleslaw,
a moment
cornbread,
ago
buffalo
that when
wings,
you
meat
received
lovers, pan
the
pizza,
clemency
vanilla ice
petition
cream,
from
2
Mr.
lemon
Humphreys,
sodas.
you recognized his name. Is that right?
That's correct.
What, if anything, did you do with that information? Did you inform anyone that you knew something about this case?
To the best of my recollection, I informed our executive director as well as our legal staff when I heard about the Cobb County case, and I indicated that was probably the case that was a change of venue brought to Glynn County.
Okay, and was that, sorry, excuse me, I didn't mean to cut you off.
And that just turned out to be so that it was Mr. Humphrey's case coming from Cobb County.
Okay, and was that before December 4th when Mr. Humphrey's team reached out to Ms. Smith to flag what Mr. Humphreys contends is a potential conflict involving your involvement?
No, not at that time. I don't believe that the dates, and I really don't have any information as to when Ms. Smith was notified of my conversations with our executive director to my participation in the trial.
Okay, and so your understanding is that whatever was brought to Ms. Smith's attention was separate and apart from you raising this issue or asking the question about your knowledge of the Humphreys trial that you brought up with the executive director. Is that right?
If I understand your question correctly, I wasn't concerned at that particular time of any standing that I would have in making a decision on Mr. Humphreys because of all my lack of participation. Mr. Humphreys' trial was minimal at best.
Okay, and then this was something that you just wanted to raise regardless of the limited involvement. Is that right?
Well, first it started out as a general conversation, but then as we talked about it in the following weeks, I became aware that it could be a point of law with the Constitution, and we have worked closely together in resolving it.
Okay. And was there a point where you were concerned that maybe you would not be an appropriate person to decide Mr. Humphrey's case, his clemency application, based on the specific facts and involvement that you had?
Well, it's my thought that we need to abide by the law and the Constitution, and I think that's why we're here today, for our judge to make a decision, and whatever his decision is, and that's what I'm going to accept and abide by.
Understood, and certainly appreciate it. Do you recall when this first conversation took place, where you raised this issue with the executive director?
No, I do not.
Okay. Was that in this month, in the last 2 weeks, or was it before that?
I'd say it was in the last 60 days.
Okay.
I can't pinpoint it. I'm not trying to be evasive. I just can't pinpoint it because I've had so many conversations about so many different things with our executive director.
No, that's very appreciated. And so you can narrow it down to within the last 60 days. To me, that says that you think it was longer than 14 days ago.
I'm going to object. He's badgering the witness. Witness has said he doesn't know, and he's been pushed into giving the 60-day, and we just keep pushing.
Okay, I don't think we've reached the badgering stage yet, but you can ask this question, then we'll move on to another topic. Do you need him to repeat the question?
Yeah, if you would, please.
Yeah, sorry. When you said 60 days, I mean, do you think it's closer to 60 days ago or 30 days ago? Or do you think it's possible that the first time you ever talked about this with anyone was 10 days ago?
It's really so difficult to say. We have so many conversations, not only with myself and just the executive director, but as the board in general. I don't document these conversations as to the date and time and the length of the conversation. So I cannot definitely say when, where, and how long these incidents took place.
Understood. All right. So I understand your representation earlier that whatever the court tells you to do, you're going to do. But do you have an opinion, a personal opinion, about whether you should serve as a decider of Mr. Humphrey's fate in this matter, based on your connection to the trial in 2007 in Glynn County?
I don't think my connection with the trial has any bearing on me as a board member making a decision from the evidence that we will review and the testimony that we will hear during that hearing. As I mentioned before, I'm a factual person. I believe in the evidence and the rule of law, and that's what I go by. I can't bring in past experience from 18 years ago that would make up my mind or my decision process one way or the other.
Thank you, Mr. Bennett, for the patience and for your testimony. I don't have any more questions for you at this time.
Ms. Piper, do you have any questions for Mr. Bennett?
Your Honor, if I may, just a few short.
Sure. You may. I just, you should go for it.
Thank you.
Defendant killed 2 women.
Hi, Mr. Bennett. I have just a few questions regarding, and the next series of questions I'm going to ask are going to relate to 2007. So we can just assume this is at the time of the trial. Can you tell the judge, approximately how many deputies you think were employed by you as a sheriff in 2007?
At least 100.
Are you referring to actually certified police officer deputies, or
yes,
detention officers included in that?
I'm referring specifically to individuals who would have been certified to provide court security or security usage agreement.
For court security, I would say at that time, maybe 45 to 50 actually deputies that could be put in a position to serve for transportation and security at the courthouse.
And in your experience in 2007, was it uncommon for cases to get transferred to Glenn County from another county?
No. And I think the judge alluded to it earlier. It's not a bad place to be. And we did have, and still do have, a reputation of having a very secure jail and a secure courthouse.
And did you ever provide security during any time during Humphrey's trial in the courtroom?
No, it was all the duties of my staff to perform those duties.
And what about security at the Holiday Inn? Did you personally provide security at any time during the trial of Mr. Humphreys?
No, I did not.
And when you said you, under the normal course of business, would have talked to the Cobb sheriffs, I believe your exact words, to discuss particular needs of an inmate. Can you just flesh out what you mean by particular needs, what you would find out from the transferring county about an inmate typically?
The gist of the conversation would have been, and probably was, of anything out of the common attitude of the inmate, his abilities to abscond, his abilities to resist, and of any special needs. We needed to know if he was ambulatory, and the medications he was taking, which would be transferred to his medical file. But we try very hard to be prepared for the inmates coming to our facility so that we can properly care for them.
And was that a routine discussion you would have for any transferring?
It was done that way each and every time.
All right. And speaking of each and every time, I want to jump over to the letter, the how we do letter, and ask you just a couple of questions on that. You indicated it was a form letter that was slightly altered for each of the juries. Who actually altered, let's say, or manipulated that form to send to each of the juries? Was that you? Did you personally participate in manipulating those forms so that they could go out?
Well, actually, there were several different forms. It depended on the type of case that was heard by the jurors. Sometimes the jury was only in session for hours, and sometimes for weeks. And maybe on one or two occasions, it exceeded the 30-day mark. So you would alter the letter that would pertain to that particular case.
And did you personally alter those letters? Did you go on the computer and alter those letters? That's what I'm asking.
I wouldn't say I'd go in the computer, but I'd say that I would have some advice and some input. It just depended on the case.
Okay. And those letters invited a response. You're soliciting, how we do, you're soliciting information. Do you have any recollection of receiving any responses? You were asked about phone calls, but do you have a recollection of any written responses related to the Humphreys trial that you would have received?
No, ma'am, I do not.
I believe those are my questions, Your Honor.
All right. Any follow-up from petitioner's side?
Just one moment, Your Honor.
Did you sign the letters personally, or is that an auto pen stamp?
And Mr. Bennett, in your tenure as a board member, which for the entirety of your tenure, have you declared a conflict at any point while serving on the Board of Pardons and Parole?
No, I have not.
Okay. Have you
Heard any other cases for which?
signed the conflict awareness affidavit?
No, I have not.
Okay.
Are you talking about in this particular case or?
Any.
In any case.
No, none.
Thank you.
He doesn't feel he has a conflict in anything.
Mr. Bennett, I have one question. When you say executive director, is that Ms. Smith? Who's the executive director for the board?
Chris Barnett.
Okay.
Ms. Smith is our legal counsel.
Got it. Okay. Mr. Bennett, thank you for making yourself available. You're welcome to stay on the Zoom session. You can, if you know how, you can turn the camera off. You're welcome to leave it on. I'm going to take you off the main screen.
Can turn it off.
But I appreciate you being present for this.
Thank you, Your Honor.
All right. Any other evidence that you all want to take at this time?
Yes, Your Honor. We'd like to call Ms. McCoy.
Why?
Ms. McCoy is also on the board.
Up until about less than 24 hours ago, Ms. McCoy was going to be hearing clemency application of Mr. Humphreys. Overnight, we found out that that was not going to be the case anymore. However, in order to perfect the record and to understand the nature of the conflict, whether or not Ms. McCoy discussed this case with others on the board, and to learn what exactly abstention might mean, we would like to ask for a couple questions regarding those topics.
Wow.
So that would be 6 questions, 3 topics, a couple each.
Well, I wish I could promise you it'll be 6 questions, Your Honor, but I don't know if it'll be exactly that many, but we'd like to have the opportunity to develop the factual record on that piece.
Okay. I'm going to hear from Ms. Piper in a moment, but my thought is you don't need to ask any questions about the conflict. It's really clear, but it's fair. It'd be fair to ask about that. I just don't think it's necessary. I think it is appropriate to ask about what would abstention mean in your mind. Your second 2 topics, you should explore those. How do you see procedurally this working? You sit there and you never say anything, or you participate fully and you don't vote. So explore that. And your other topic of what have you told others about your knowledge about the Humphreys case? Those 2, feel free to explore, but I'm going to ask you to leave the other one alone, in part because you could go all day establishing the conflict. It's that broad, it's that deep, it's that obvious, so you don't need to. Okay? All right.
Okay, I don't know who is speaking for the petitioner.
And I can go up to the...
Okay, we'll fix that. We'll fix that in a minute. It's always been the same person. It's the 3rd name that you got on the list. That's Mr. Garabadu. And I'll have him come up to the podium in a minute. But before he does that, Ms. Piper, any objection to having Ms. McCoy testify about the 2 areas? Mr. Garabadu identified 3. I'm saying let's talk about 2. Any objection to that?
I would do a general relevance. She's conflicted out, right? She has said, I'm abstaining from the vote. If Your Honor would like to hear information on that, I would just ask that it be limited as you have limited.
Okay. Well, great. We'll do it my way. Why don't you come on up? And Ms. McCoy, if you could turn your camera on, please.
They're not sequestered? She gets to listen to the whole thing?
There she is. Thank you, Ms. McCoy. We don't have a deputy right now.
Judge, you can swear him in. You're an officer of the court.
I'll swear you in. Raise your right hand.
That was my idea.
Do you swear or affirm that the contents of your testimony will be true and correct to the best of your belief and knowledge? Nope, that's the wrong oath. That's if you had an affidavit. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
Excellent. Let's follow that one. She's under oath.
All right. Good afternoon, Ms. McCoy. Can you see me on one of the 18 different cameras that are?
You know what? I can make that happen. If you'll move that screen a little bit, the podium screen works, and then angle it up. There we go.
Ooh, look at that.
And then we'll
All right.
add. There we go.
Judge,
and why don't you
Zoom
state
Pro.
your name one more time for our court reporter?
Rahul Garabadu for the petitioner.
And she's already got your name. So now we'll go.
Names.
Great. Good afternoon, Ms. McCoy. I'm going to be asking you a few questions about, on behalf of my client, Mr. Humphreys. Now, Ms. McCoy, you served as director of the Victim Witness Unit for the Cobb County DA's office from April of 1999 to April of 2024. Is that right?
That's correct.
All right. And just to be clear, you're an employee of the Cobb DA's office in that role, right?
That is correct.
Okay. So you were paid by the Cobb DA's office?
Cobb County government, yes, Cobb County
This
DA's
one.
office.
Not the board.
And you were appointed to the State Board of Pardons and Paroles by Governor Kemp effective December 1st, 2025, right?
That is correct.
So it is your second full week, or we're going into your third full week on the job.
Yes.
Now, Your Honor, I am showing the witness what's been marked as Exhibit 2 on the screen.
Is this 2 also from your binder, or
Yes,
it's a different?
It is 2 on the binder. It's
Okay.
2. I'm going to share my screen. Ms. McCoy, can you see the document I'm displaying for you right now that says the State of Georgia Executive Order at the top?
I can.
All right. And do you recognize this document?
I do.
And this is a document that appoints you as a member of the State Board of Pardon and Paroles. Is that right?
Brand new.
Can you scroll down so I can see the remainder of the document?
Yes. And let me know if I need to zoom out too. I can do that as well.
That appears to be the document, yes.
That's the one. That's the one that gives me my job.
Your Honor, we move Exhibit 2 into evidence.
Any objection?
No objection.
All right. It's still official. You started as of December 1.
Yes, sir.
Now, Ms. McCoy, did you apply for a position on the board, or did someone reach out to you about the appointment?
I'm going to object to relevance on this question, and we're going outside the scope of the narrow topics you asked us.
So you can talk to me about how it's relevant, but then there's 2 topics. It's how do you envision your role in this clemency hearing, this one, Humphreys, and what, if anything, have you shared with other members of the board, or do you plan to share with other members of the board about what you, meaning Ms. McCoy, knows about the Humphreys case trial?
Yes, Your Honor. This is just leading up to kind of parole on the board, and then we are getting to the abstention piece and the communicating piece. But I just want to understand, how she came to be in that position. If that involved other members of the board, for example, that might be relevant as to what Ms. McCoy might have shared with them before coming onto the board. With the bar for relevance being so low, Your Honor, I'd ask for a little leeway here.
Okay, it's a low bar. You have a little leeway, but let's get to our 2 topics.
Yes, Your Honor. So, Ms. McCoy, did you apply for a position on the board, or did someone reach out to you about the appointment? How did you get to be on the Board of Pardons and Paroles?
I had several people reach out to me asking me if I would consider the appointment, or consider being considered for the appointment. I had a former elected district attorney, retired district attorney, who submitted my name for nomination.
Okay, and who were the folks who reached out to you about considering a position on the board?
I don't.
Listen. Yeah, you weren't here.
I'm sorry. Am I to answer?
Go ahead, Ms. McCoy.
I don't know that I can tell you everybody that asked me if I would consider being nominated, because some of that happened at a retirement party There were numerous people there.
Everyone was
I
drunk.
was asked by retired district attorney. No, I'm sorry. That is not who I was asked by.
Let me make the question a little easier for you then, Ms. McCoy. Did any of the current members of the Board of Pardons and Paroles reach out to you about applying for the position?
No.
Okay. I want to talk to you a little bit about how the board handles clemency applications generally. When the board receives a clemency application, how is it processed by the board?
I can't answer that question in generalities because this is my third week on the job and this is the first application for clemency I've seen.
And I'm going to object. That doesn't sound like one of those two topics.
We're getting there, Your Honor.
Boy, it's an indirect way of getting there. I'm going to ask you a question, Ms. McCoy. Have you discussed with any of the other 4 members of the board your knowledge about Mr. Humphrey's case?
My knowledge about the case? No, sir.
Okay. The way you answered my question suggests you've discussed something else about the Humphreys case with the other board members. What would that be?
A conflict.
My only discussion with any of the board members has been with Mr. Bennett, and that discussion was the lawsuit that was filed.
The lawsuit meaning what we're doing right now?
Yes, sir.
Okay. Gosh, that's a harsh name for it. I mean, no one's being sued like we're going to get damages. They're doing what they need to do on behalf of their client, but I guess it named you, so it feels like you're being sued. On your first day on the job?
Yes, sir.
Okay. 11th. But in terms of substance, sitting down with the board member saying, man, let me tell you about the Humphreys trial. I was there. I sat with Ms. Williams' family, Ms. Brown's family. Nothing like that's happened.
No, sir.
Okay. That's one of the 2 topics.
Yeah, we're halfway done.
Yes, Your Honor. And just following up on that question, did you ever bring it up with the ethics officer of the board about your involvement in the Humphreys trial?
I discussed this with internal counsel Laquan Smith and with executive director Chris Barnett.
Is there a separate ethics officer, or is Ms. Smith effectively as counsel? That's who you'd go to saying, hey, there could be an issue with the fact that I was the victim witness advocate in this case.
Correct.
Okay.
That's right. Okay.
Is Chris
I want to
Barnett
make sure you
different
don't
from
think, counsel, that there is also an ethics officer that Ms. McCoy didn't go to.
No. My question was whether or not Ms. McCoy consulted with Ms. Smith.
Okay.
And it sounds like she did.
Okay.
And Ms. McCoy, when did you have that conversation with Ms. Smith?
May I look at a calendar?
You may. I guess you only have 11 days to choose from.
Yes, sir. To the best of my recollection, that was December the 4th.
December the 4th.
So 11 days ago.
And did that conversation happen right after you heard that Mr. Humphrey's clemency application was going to be reviewed by the board? Let me make that question a little simpler. When did you find out that Mr. Humphrey's clemency application was being heard by the board?
I found out that the death warrant was signed on, I believe it was December the 2nd.
It's not a warrant we hear a lot about.
And did that trigger in your mind that, that means I'm going to be dealing with this because death warrant means clemency hearing?
Yes, sir.
Okay.
Okay. So when you heard about the death warrant being signed, that was what triggered your conversation with Ms. Smith?
That triggered my conversation with Executive Director Barnett.
Okay. And what did you discuss with Executive Director Barnett?
That I needed to advise him that I was the advocate assigned on the case back in 2007, that I
She was
would
the victim advocate?
Await direction from the board's legal counsel as to whether or not there needed to be further discussion about that. Just general conversation about how to proceed.
And did you receive guidance from either Mr. Barnett or Ms. Smith after that conversation?
I did.
Okay. When did you hear kind of about your next steps as it related to Mr. Humphrey's clemency application?
We had several conversations. I'm sorry, I can't tell you exact dates. I mean, we had conversations even deep into the weekend.
Okay. Do you remember if this was, again, 11 days to choose from, would this have been your first full week as a board member or your second full week? Can you remember, or was it that weekend straddling those 2 weeks?
I'm sorry, I don't understand your question.
I guess I'm just trying to ask, do you
You
remember
lost me at
if it
straddling.
was closer to your first day on the job or if it was this past week?
I have had general conversations with Executive Director Barnett and with Ms. Smith since December the 2nd.
Okay. And based on that conversation, did either Mr. Barnett or Ms. Smith tell you that you needed to recuse yourself from the case?
Protected information, right? That's legal counsel. Whoa, she's waiting for an
I'm
objection.
hesitating because I don't recall those exact words being said.
What do you recall being said as it related to your participation in the Humphreys clemency application?
That I took an oath as a board member of the State Board of Pardons and Paroles, that I swore under oath to uphold the rules of the board, that any knowledge that I might have had of the case could be different from information that is provided to me during the clemency hearing. I had some discussions with Ms. Smith about my involvement with the case. General conversation about board procedures. I'm sorry, I don't know specifically. Those are the things that I have had conversations about.
If the clemency hearing were to have gone forward tomorrow at 9 a.m., what were you planning on doing?
Sounds
were
like
you going to be in the room with headphones on, not in the room? What would you be doing?
I have not had that thought, sir, because I have abstained, and then this morning I knew that there was a stay, so I have not had that thought.
Okay, tell me what you mean when you say you abstained.
That I abstained from the vote in the clemency decision.
Okay, but does that mean you wouldn't be present for that particular hearing? And so the other four would take care of it, or you'd be there, but when it was time to vote, you would say the word abstain rather than yes or no, or I don't know what words, grant, deny, but you wouldn't be saying any of those words. You'd say the word abstain.
The only conversations that I had with how that would happen was with the Attorney General's office.
Okay, well, I don't want to get into that. But I guess, so you haven't reached a vision in your mind as to what your participation, because this will happen. There will be a clemency hearing for Mr. Humphreys. And I need to understand, given the lawsuit, as you called it, that's in front of me, what does it mean for you to abstain? Are you going to be there and do what everyone else does except vote? Are you there but you sit mute? Are you not there at all? Those are different.
Yes, sir. My answer to your question is I'm going to do what the court directs me to do.
You sound a lot like Mr. Bennett, but I want to get it right. And I may not have to direct you at all if you were saying, you know, I actually get a day off from Board of Pardons and Paroles work on Mr. Humphrey's clemency hearing day because I'm not going to be there because I'll be, to use your word, I'll be abstaining and you'll be going about your life in a different way. But it sounds like that hasn't necessarily crystallized for you what abstaining means.
That is correct, sir, because I have, as I told the board in the AG's office, would be awaiting direction as to what I needed to do.
Okay. I appreciate that. Thank you.
Well, your failure to answer that question.
When exactly was the decision made that you were going to abstain from the clemency application hearing?
Last night.
Last night, okay. In your conversations and in your considerations regarding the Humphreys clemency application, did you consult the ethical guidelines for the Board of Pardons and Paroles?
Will you repeat the first part of that question? I apologize.
Sure. You've indicated today in court that you've spent some portion of the last 2 weeks thinking about the Humphreys clemency application and what you might do. As part of those considerations, did you consult the ethical guidelines of the Board of Pardons and Paroles?
I read over them, yes.
Okay. And you'd be familiar with them if I showed them to you right now?
Yes.
Your Honor, I'm showing the witness what's been marked as Exhibit 14, which are the Board of Pardon and Parole's ethical guidelines. Ms. McCoy, can you see my screen?
Yes.
Okay. And I'm going to scroll through this.
Not anymore. You made it
and
small.
You can tell me to slow down if you need me to.
Can you make it larger, please?
Yes. Is that large enough? Do you need it larger?
Yes, thank you.
Okay. And tell me if I need to go slower.
We've got 12 pages. Speed it up, dude. 12 pages. Go, go, go. This is the table of contents. Gift. No gifts. Vendors. No inappropriate relationships between vendors and board members.
So that looks like it's lots of pages. Are you going to go to a specific spot?
I am. I just want to confirm that this is Ms. McCoy, does this look like a fair and accurate copy of the ethical guidelines that
Ms. Piper, you're not challenging that this is not a copy.
So stipulated.
It's a copy.
All right. Your Honor, this time we'd move to enter these ethical guidelines into evidence.
Do they have an exhibit number?
Yes,
you may
they're
have said
Exhibit
that.
14.
Exhibit 14. There they are. Any objection to petitioners 14?
Objection.
Admitted.
Okay. Now, Ms. McCoy, I want to direct you to Rule 1.105.2, which I'm going to scroll to right now.
Employees shall make every effort to avoid even the appearance of conflict
Do you
of
see
interest.
Rule 1.105.2?
Reasonable person would conclude from the circumstance that employees' ability to protect the public
That
interest.
rule notes that employees should make every effort to avoid even the appearance of a conflict of interest, right?
Yes. May I have 1 minute to read this, please?
Absolutely.
This is new to me. I didn't get this far.
While she's reading this, question for you, Counselor. Given that Ms. McCoy is abstaining, whatever that turns out to mean, why are we exploring this?
Your Honor, I think we haven't quite gotten to the bottom of what led to the decision to abstain. And so I'm trying to get a little more clarity through the ethical guidelines as to what Ms. McCoy might have consulted to get to that question of what abstention is.
But don't you have the dilemma for you that what Ms. McCoy has said is, I talked to the executive director, I talked to counsel, then I talked to the attorney general. And the result of that conversation was that I'm abstaining. And so what led her to abstain was, as the record stands right now, the attorney general's office and I had a conversation, the substance of which we may not explore, lawyer, client. So I don't want, and I think Ms. McCoy doesn't want to, not in the sense that she's not wanting to give full answers, but she knows that it's a privileged conversation. So you're bumping up against that.
May I also object on relevancy, but let's assume, for sake of argument, there was some violation. The violation of the policy is not what we're talking about here.
Well, because she's abstaining, whatever abstaining means. Right. So why don't you go ahead and ask a question, but I just don't want poor Ms. McCoy to get by like, well, that's not the whole thing, and I should read 1.1053. She may feel on the spot, I'm getting quizzed on the ethical guidelines. And that's not what, I know that's not what you're intending, but I just don't want her to be in that position because it's not where we're going with this anyway.
Yes, Your Honor. And to be very clear, I'm not asking Ms. McCoy to breach attorney-client privilege at all.
Good.
What I heard in Ms. McCoy's earlier answer was that she was given a lot of information from Mr. Barnett, from Ms. Smith, that she took into consideration. She was then given, it sounded like before I asked her these questions, she had looked at these rules, and it was only when the Attorney General conversation took place, that was what triggered the abstention. And so
she wasn't going to, but she did.
What we're trying to get to the bottom of is, was it the lawsuit that triggered the abstention? And if so,
then so what? I don't, just to cut to the chase, how does that affect the decision you want me to make? Whether it was the lawsuit or she looked at, hey, I better look at my horoscope today. Oop, don't commit an ethical violation.
Well, Your Honor, it goes to the question of whether or not the conflicts of interest, whether it's in Ms. McCoy's case or Mr. Bennett's case, are actually being implemented by the board.
And in a larger picture, that might be something that someone might want to explore, but we're here for Mr. Humphreys. And Ms. McCoy has said, I won't be participating at a minimum in the vote as to clemency. So why don't you ask two more questions about, because you said you're asking couples. Ask a couple questions about this, and then we're going to move on from the ethical guidelines, because Ms. McCoy has reached the point that you were advocating for. Mm-hmm. At least she's not going to vote. Whether she's going to not be in the room, we're going to figure that out.
Yes. Yes, Your Honor. And in that case, Ms. McCoy, I actually want to direct your attention then to Rule 1.106.2, which talks about recusal.
106.2. An employee shall recuse
All right,
himself
Ms.
or
McCoy,
herself.
can you see 1.106.2, the rule about recusal?
Yes.
So, Ms. McCoy,
why aren't you
that
recusing
rule,
yourself?
Talks about when a board member needs to recuse themselves. And it mentions the term, right underneath that, it mentions the term, it defines the term participant. And it says that a participant includes, but is not limited to, a person, an owner, shareholder, partner, employee, or agent of a business entity involved in the proceeding. So recusing under that definition means you can't be involved in the proceeding. Is that your understanding?
I'm going to object that we're getting into having this witness who, the relevance of what she defines as a word in a policy as irrelevant to these proceedings.
Your Honor, if I may.
You may.
This goes back to what the daylight between recusal versus abstention.
Okay, I am overruling the objection. Can you scroll it up or down? I want to, there we go. Great. Okay.
So, Ms. McCoy, do you,
Due to the
as a
employee's
member of the
personal or
board,
financial relationship with the
see a
participant.
difference between recusal, which under these definitions says that you could not be involved in any proceeding, versus abstention?
I'm going to object to
Overruled.
recusal is not defined that way. Participation may be defined a certain way, but recusal is not defined in such a manner. And that's misstating the evidence.
When you look at 106.2, Ms. McCoy, no, don't go a little way. What does the word recuse say to you? If you felt you were in a situation to which that provision applies, oh, that's me, I need to recuse. What are you doing? If you are recusing, tell me what it is you think you're doing.
Removing myself from the situation.
That's good. But now put that in concrete terms. I don't go to that meeting. I don't talk about it at all. I'm completely walled off for that one situation. You can give me all the other cases, or you're there with everyone else, but you aren't particularly participative when they're talking about that case.
A recusal means completely walled off from the issue at hand. However,
So she wouldn't be hearing
if you
it.
continue to read 1.106.2, it says because of an employee's personal or financial relationship. That is the basis of the recusal.
Okay. I see what it says. I was focused on the fourth word there, recuse, and because you have said I'm abstaining and you didn't say recuse, you said abstain. And you can understand why I'm trying to figure out, well, what does abstain mean? Because abstain isn't what it says anywhere in the policy you're supposed to do if there's a conflict. It says recuse. And I don't think it's a coincidence that your attorneys, for the purposes of this litigation, the Attorney General's office, said you'd be abstaining. They didn't say recuse. They're smart people. They choose their words carefully, and they said that you'd be abstaining. And so that's why we're going around and around on this.
Yes, sir.
All right. Any other questions?
Just to follow up on that point. So, Ms. McCoy, you did not believe that you had personal involvement in the Humphreys trial?
I had involvement with the Humphreys trial because I was the assigned advocate to work that case at the time.
That sounds rather personal.
So is that a yes to my question? You did not think that was a personal involvement of yours?
It was not a personal involvement in that I was employed as a victim advocate at the time of that case. I was assigned as the victim advocate in that case, and I performed my roles as a victim advocate pursuant to the Crime Victims Bill of Rights in that case.
Okay. Your Honor, may I confer with my co-counsel for a moment?
You may.
Okay, so it already
Deputy
brings
Gordon,
up.
could you grab this? It goes to
It already brings up
Ms.
employee.
McAdams. I think she may be outside. Make sure I got the right name. Yeah, Ms. McAdams. Thanks.
Okay. From any proceeding in which the employee has a conflict of interest.
Your Honor,
She
may we take
was.
a 5-minute break to confer and come back? Would that be okay?
I bet you that Investigator Wilson would appreciate that, because then I can read his warrants and get him out the door. He's learned more about abstain versus recusal than he ever wanted to. You all right with that, Ms. Piper, if we take a few-minute break?
Yes, Your Honor.
Okay. When we get back, you should not have many questions left for Ms. McCoy, given what we all agreed you'd be exploring with her.
The 5-minute break will help to ensure.
Validate?
Yes.
Okay. All right. We're off the record for a few minutes.
An employee shall recuse
I'm gonna
himself.
go read these. When I come
or
back out, I'll
herself.
swear you in, okay? Thanks. Appreciate your patience. I hope you're on the clock at least. Good.
From any proceeding in which the employee has a conflict of interest.
I didn't understand the word, the something Bill of Rights.
Crime victims.
Crime victims, yeah.
Crime victims, thank you.
That's our court reporter. Guess we get to watch
So there's
this.
that word.
Yeah, the hearing has been postponed. But that doesn't. The death warrant is still valid until the 24th of December. Okay, while they talk, I'm going to turn that off for a second. This is from Josh. The clemency hearing for tomorrow has been canceled. According to Atlanta Journal-Constitution, Wednesday's scheduled execution of a death row prisoner is on hold for now after the Georgia Board of Pardons and Paroles abruptly canceled the clemency hearing set for Tuesday morning. The decision was announced during an emergency hearing seeking to halt the execution of Stacey Ian Humphreys, who was scheduled to die by lethal injection for the 2003 murders of 2 Cobb County real estate agents. Roughly an hour before this hearing started, there was a stay of execution issued. Humphrey's attorney, Jessica Gable-Sino, told Fulton County Superior Court Judge Robert McKerney, neither Humphrey's legal team nor the attorneys representing the state could say exactly why Tuesday's clemency hearing was being postponed. Well, now we know. They have conflict issues. Board of Pardons and Paroles spokesman Steve Hayes said the hearing was suspended in response to a motion filed by Humphrey's representatives, but couldn't say for certain whether the clemency hearing would be rescheduled within the execution window, which expires December 24th. So as soon as they have this, literally, the clemency hearing is the last checkmark on the death row legal process before they can execute him. Once that's done, it's we roll at midnight. It's a done deal, but it has to happen before December 24th or by December 24th. The board didn't want to get into a position of starting a clemency meeting where there was an outstanding court proceeding, said Hayes. So they said they canceled out of precaution. Humphrey's attorneys are arguing that 2 of the 5 members of the Board of Pardons and Paroles have a conflict of interest and should be recused from Humphrey's clemency hearing. Let's see. So in the filing, McCoy, she just got picked up for this job on the 1st of December, decided to abstain from voting last night, but did not recuse herself from the hearing. The defense attorneys argue that another board member, Wayne Bennett, who was the sheriff, should be recused because of his conflict, but he was the sheriff at the time that this guy went through the trial system. He wasn't like talking with the guy personally. He didn't have a personal connection. 5 board members need to be present, but there are also some legal limits to how many board members there are and how they get appointed. The Supreme Court did just turn down the Humphreys appeal. Christmas Eve, that's not a great present. Yeah, it's wild. Can't a governor intervene? I think a governor can intervene. I think most states allow this. The governor can intervene up until the last moment. But generally, you don't want to put it last moment because you might sign the paperwork and make the call. But when you make the call, it's like, oh, we just gave the injection. Oops. You've got to give them a little buffer window. Something feels off here. This is, we're watching a screen share and a court reporter who is narrating things. This is about as late stage legal process as you can possibly imagine. I mean, this is the last ditch effort of a death row condemned man. Now, if the facts of the case are what they are, this guy, I can see why the jury went with the death penalty. I can see why they went with the ultimate punishment, because the facts of the case, this wasn't just a robbery. I mean, he first of all, it's with a firearm, enters an office where these 2 women are working, or one's there, forces her to strip, gags her with her own underwear, ties her up, uses a gun to to force her to reveal the PIN number for her credit card stuff, basically robs her and then kills her. And then the other lady comes in and does the same thing with her, gets her PIN information as well. Then he leaves. Somebody else hears him leaving, like the door chime leaving, thinks it's them arriving. He walks in, finds the first woman dead. The cops show up, find the second woman as well. And he goes off. He doesn't show up to work, uses their PIN to withdraw like $3,000 from their accounts, blows $1,200 of it, has $800 in his pocket, and puts $1,000 in his account. And they catch him in Wisconsin on the run. This guy was, a piece of work for sure. And yeah. Who let him out? Well, his priors are a lot of thefts. He probably served his time on his priors. I don't think he ever, he did have some assaults and some kidnappings. Those might be related to this case. I'm not sure if they are. But his priors were mostly theft and impersonating someone and things like that. So he probably just served a lot of time and then got out. Well, at least Wisconsin's pretty good at catching our criminals, I guess. I know. And man, it's hard to not think about the current manhunt that's going on in Rhode Island and the surrounding areas, as they had a shooting over the weekend as well at Brown University that their guy walked away. And they named like 3 or 4 people of interest, pictures all over the internet. It's like, oh, it's this guy, that guy, this guy. Even the guy they caught, they're like, nope, it wasn't him. If you know who it was, let us know. There are 800 cameras around that, and all we've got is a grainy image that makes Bigfoot laugh. We've got better pictures of Bigfoot than we do of this guy. Anyway, all right. My gripe about cameras, right? There's no excuse in today's day and age for a 480p definition camera when high definition is dirt cheap, and storage is so cheap. Bigfoot is photogenic. Good stuff. Okay, we're just waiting for the break to get over here.
You.
Here we go. Everyone's back in the courtroom. Just waiting for the judge, who is off in the back room signing warrants.
I'm scared this tonight. I've made it through. I have made it through December without sick kids.
I know the sick kids.
Yeah.
We're all better here. We've all recovered, but Rhode Islander here, uneasy till they find him. Pentaphylate, I hear you. It's terrible. I wish we had more information to go by.
Yeah.
Well, it doesn't take much to get out of Rhode Island, honestly. Contrary to popular belief, it's not an island, right? It does, in fact, have borders you can just cross and walk over.
Yeah, just anything that.
Safest person action. Yeah.
I want to hear these last couple questions.
Right now, and they're serious. So you have to find it out. Instead, I'll just be like, understand.
Investigator, come on up. So what you're trying to get is a dump from the tower for that window that will basically say, here are the 500 phones that were hitting the tower. But because you're looking for a bunch of towers, because where these guys were in the Bronco or whatever else it was, like, hey, this is the only number that's in all three of those places. And so it's sort of like a geofence, but a kind of crude version.
So it is, and then also the Bronco itself, if I was to, yes.
Okay, got it. No, that's all right. Then I get it. And we think it's the same guys. It's just 2 different days. They had 2 different stolen cars when they were doing it. Hey, I was with Chief Smith one day at a meeting. Like, hey, we need to add entering auto to things that can divert. It's like, we are not doing that. Entering autos, they're run by these guys. They're big teams.
Get some rest. Thank you so much.
This is a business. I was thinking of like the homeless guy who breaks into a car to take something. He's like, we're not going, that's not divertible. Now that I read this, I should have read this just before I went to the meeting. Yeah, I hear you, Chief. He didn't like that idea at all. Like, all right, I'll drop it. All right, you swear or affirm that the contents of your affidavits are true and correct to the best of your belief and knowledge?
Yes.
Excellent. Sorry for the wait.
Okay.
He signed the warrant.
But you could see we were busy. No one was playing video games or whatever.
And it's not a time-sensitive one. The geofence information can be looked back. It's retrospective. I don't like those warrants, though. Show us everyone who was in this area at this time by their cell phone. Okay, Josh is the only one here. As soon as Red Pen officially goes out the door, you're all able to start acting up because he can't get you all. No, just kidding, Josh.
You need to
be nice to
sign.
Josh.
Do you have a pen or you need one?
Oh, I have one that's black.
Amber's here, never mind.
Blue's better. Okay, here you go. Here's your folder. Do you want a paper clip or just a folder?
That's fine.
With so many vehicles with the Bronco, how do you do that? I mean, they're just punching the windows.
Punching the windows, taking things, electronics,
Guns, yeah.
Yes.
It's amazing how many people leave them in the car.
It's amazing how many people leave a gun in their car. This is true.
All right, and then if you sign right there. Great, appreciate your patience. Good luck out there.
I appreciate it. Thank you.
Yeah, she's all right, let's get back on the record, please.
We're back on.
We're back on. Excellent. Thank you, Ms. Nichols. We're back on the record in the Humphreys matter. And you said 1 or 2 questions left.
Your Honor, I have even better news for you than that. I am about to take my seat, and I have no further questions right now for Ms. McCoy. I did have 2 administrative things I wanted to address with you just before I sat down. The first is that during the break, we consulted with opposing counsel about admitting exhibits, or stipulating to exhibits 1 through 14 in that binder in front of you.
Okay.
Those were attached to our petition. Opposing counsel, and they can correct me if I'm wrong, but they have agreed to stipulate to the admission of 1 through 14. For exhibits 5 and 6, they have stipulated to its authenticity only, though.
Not to the content.
Not to the content.
Got it. Which is an affidavit of a last name I can't pronounce, and then Bandrowski, 2 affidavits. So
that's correct.
They'll be made part of the record.
Yes.
Of this proceeding. Someone needs to get those exhibits to the court reporter who will be creating that record. The respondents aren't saying those affidavits are accurate or correct, but yes, those are the sworn affidavits of initials DAC as well as initials LB.
Yes,
okay.
Your Honor.
Is that a fair statement, Ms. Pipers?
Yes.
Okay, done.
And the second administrative thing I wanted to mention before I sat down, Your Honor, we had subpoenaed Ms. McCoy's personnel file from the Cobb County DA's office. I believe the Cobb County ADA is in the room with those records. They have not been redacted because of how quickly this hearing had to happen.
Right, I think the subpoena was from this morning.
That's correct. And so those records, as I understand it, are available for you. We are not able to look at it because they have not been redacted. I just mentioned that because they are, I believe the Cobb County ADA is here in the courtroom. Those records are available for you, but we don't know what's in it.
And given what I've shared on the record about my view of the existence of a conflict, do you think that there is a need for me to look at those records, or should I get them at least and put them in a sealed envelope so that they're made part of the larger record? Because I'll tell you, I wouldn't likely look at them to reach a judgment about the existence of a conflict. That's not me then saying, so what about that conflict? But at a minimum, the appearance of a conflict. And that's really what guides this analysis, how a layperson who sat through the trial in Glynn County day after day, seeing Ms. McCoy do the amazing work that a victim advocate does, not with the defendant, but with the families of the victims, then seeing Ms. McCoy in the room for a clemency hearing, that neutral observer would say, how is this the right way to do things? And it doesn't impute anything to Ms. McCoy, just on the surface, it speaks of conflict. So because of that, I don't know that I would look at those records. That doesn't mean you can't make them part of a larger record so that more powerful judges could look at it in the future. But obviously that should be sealed because it shouldn't be readable, even if it were redacted. It's a personnel file. And so I'm offering that up. If you want to, you don't need to get it to me, you'd get it to, well, I don't know how we would handle making it a sealed record.
Your Honor, may I take a moment to confer with my advisor?
Why don't we do this? Because who has the files?
I do, Judge. I probably should clarify. My name is Jesse Evans. We've met before.
I know you, Mr. Evans. I've been wondering because Mr. Evans keeps sliding over so I can see him. Like, no, hide behind the lawyer. So
I'm trying to see the proceedings here.
Yeah.
So for a court reporter's benefit, it's JESSE-EVANS, and I'm Chief Assistant District Attorney with the Cobb DA.
Yes, you are.
I have 2 sets of records, or actually technically 2 sets of records that were requested this morning. And if you deem it appropriate, I can clarify what I have in my possession.
So my thought is this for everyone, but then I'll get Mr. Evans's input first, then petitioners, then respondents. Because you subpoenaed them, there was a felt need for them. They're not irrelevant writ large. I don't think I need to process them for the work I'm being called upon to do. So unless you want to abandon the request so that Mr. Evans goes home with those copies and then destroys them, I will take them and then we'll figure out how I can get them under seal and then united with the good work that Ms. Nichols is doing. I don't think they go to Ms. Nichols because they're going to be under seal. And so my proposal is either, one, you say we abandon it based on what you said, Judge. If not, it's okay. Then I'll take them and my staff and I will figure out how to get them filed under seal under this CV number. So they will travel with the docket should this docket need to go to the Supreme Court of Georgia or somewhere on there, United States. So we'll do that. I'm good with either one. The federal defenders really want to talk.
Yes, I'm going to turn it over.
If you don't,
You need to let Ms. Nichols know who you are.
Hello, I'm Beth Wells. I'm with the Federal Defender. I represent Mr. Humphreys. I was the one who was responsible for the subpoena, so I thought it might be easier for me to address. There are actually two categories, and they may have, one category actually goes to Mr. Bennett. And so that might be relevant to considerations the court is having. And I have not had a chance to speak more at length with
Mr. Evans.
Mr. Evans, thank you. I know that he was bringing the personnel file at the time we spoke this morning. He wasn't sure if he'd be able to get the stuff relevant to Mr. Bennett.
And remind me, I read the subpoena. The part for Mr. Bennett would basically be communications with the Cobb DA's office about the role Mr. Bennett's office, the sheriff's office, would play in connection with the case.
Yes, Your Honor. And actually it would have been, unfortunately, because the hearing is truncated because of the warrant, we were hoping to have those so we could review them in our cross-examination or examination of Mr. Bennett. Okay. I don't know what's in there, but we would like the court to have them.
And Mr. Evans, you mentioned you had two things, not one thing. Is one of the things, whatever you could find in 38 minutes, related to Sheriff Bennett, and the rest is Ms. McCoy, or is it all Ms. McCoy?
I don't know. So I'll tell you what our two categories are, and I'll explain the process.
I'm sorry, I can't hear him. He needs to come up to a microphone.
Okay, we can hear you though.
Great, I'm closer to a microphone now. So the answer to the judge's inquiry is I don't know whether there's any correspondence between our office and Mr. Bennett in this file. I received word around 8:30 this morning of the existence of the subpoena. I asked my staff to start looking for things, and then it was only about noon that I was able to go by the office to pick up what I have. In one file, I'm certain that it's Ms. McCoy's personnel file. For the benefit of Ms. McCoy, who's a former colleague of mine, it has not been redacted, which is why we wanted to make sure it's under seal, because there would be some personal identifying information in there that she wouldn't want out there. The other file that we were able to locate that might have correspondence with Bennett, I don't know because I haven't looked at it, I flipped through it, is what I'll call as our victim witness work product file that we located with the file.
Got it, but really that would be probably more connected to Ms. McCoy's work, as opposed to what I understood the thrust of the petitioner's request was, is there, I don't know why it would still be there, but communication from whoever was it Pat Head who was the DA back then?
That's correct.
Between Mr. Head or the judge who handled the case, not that your office would have communications from the judge, but Cobb communication with the sheriff's team saying, here's how this is going to work, and we need you to just keep your eye on the jury, or I don't know what, I don't know why that would be in that second collection. I appreciate you getting it. I think it was the right thing to do. My guess is that there's not going to be much in there either. But here's my proposal. I will look through the second folder that is victim witness related to the trial to see if there's anything related to then Sheriff Bennett. And if so, and it seems disclosable, I'll get it to both sides. So you've got it. And we may need to reopen the record in this if we are under less time pressure given the decision of the board from earlier today. I don't think that's going to jump out of there, but who knows? So, but if there's nothing in that second file that relates to Sheriff Bennett, then I'm just going to seal it with the other McCoy documents, because I think they go not quite hand in glove, but it's at least like elbow and shoulder, because it's victim witness advocacy connection to the Humphreys trial.
I did see some email correspondence between our team that presumably was collected by Ms. McCoy and kept in there that involved attorneys and things like that. Yeah. So it's not, it wouldn't be out of the realm of the possibility that maybe there's an offhand reference to Bennett. Right. But this is not the entirety of our work product. Nope. And so
you got what you could in the window you had.
You've hit the nail on the head, Jeff.
All right. I appreciate your office's effort. I'll take it. Before we do that, Ms. Piper, you all right with the approach I described?
Given that I've already heard your opinion on the relevance, yes, sir.
Okay. All right. Thank you, Mr. Evans.
Thank you, Judge.
All right. Same. So you all understand, Judge Krause, she's in Hawaii right now. All right.
So this is why McBurney's taking this.
She better bring me back a lot of Whatever is good in Hawaii.
Macadamia nuts?
I don't actually like those, so coconut. I like coconut. Give me that.
Last administrative matter, Your Honor, and then I will sit down.
Can I take Ms. McCoy off the big screen there? All right. Don't run away, Ms. McCoy. I'll just take you off the spotlight right there. Thanks.
Your Honor, as to the remaining exhibits in the binder, those are exhibits 15 through 22. 21, excuse me, 21. We understand that opposing counsel has objections to those exhibits. We believe we could have entered those through the direct examination of Ms. McCoy had this not been a truncated proceeding. We ask that it be part of the larger record because under the exigent circumstances, we can't be here until 10 o'clock at night.
No, you can't. Well, you can.
We're not going to be here.
The door locks behind you. So why don't we do this? 1 through 14? Is it 14? Are admitted by stipulation. There are 2 exhibits, the affidavits, they're admitted. The respondents aren't admitting to their veracity or accuracy. And then 15 and 22 is also admitted. That is the bio for Mr. Bennett. So it would be 15 through 21. We'll make part of the record. I haven't looked at them. I'm not going to look at them, but I'll rely on petitioner's team to get them to Ms. Nichols to be made part of the record. But the record right now is making clear 15 through 21 are not in evidence. They aren't things that I will be relying on in making any of the decisions that I'm being asked to make. Does that address the administrative concern?
It does.
Ms. Piper, does that work for respondents?
Yes, Your Honor.
Okay.
And with that, Your Honor, I will go and sit down and turn it to my colleague, Mr. Greenermeyer.
Okay. Well, it was nice having you up at the podium. Mr. Greenermeyer, what more is there? We've had argument. Both witnesses have testified. We haven't heard anything from respondents yet.
I would like to ask 3 lines of question to Ms. Smith, which are, who did she communicate about McCoy with?
We sort of covered that already.
If she can give us any more guidelines about what recusal versus abstention means, right? Any representations?
She's not going to.
And in Fugate, there's a line that the Judge Goger found important, which was whether this was precedented or not, whether the board has ever conducted business like that. And I would like to pose that question to her.
Whether the board has ever conducted business with less than all 5 people there.
And voting. Yes.
And voted.
In a death case.
Okay. It was helpful to get a preview. Ms. Piper, do you have any objection? I know they weren't the specific questions, but it was the 3 topic areas. Topic 3 seems like fair game. I'm all right with that, insofar as Ms. Smith knows. What about the other 2 areas?
I would say with respect to, a definition in particular that Ms. McCoy has used in abstaining. They've had the opportunity to question Ms. McCoy on that. It's not what Quan thinks is the definition versus a definition is not really relevant. She's a legal ethics officer. That's it. She's not speaking on behalf of respondents in defining this term.
Okay.
To get her to testify as such, I think would be inappropriate.
Okay. I'll let you explore those areas. I may close things down on the Ms. Smith's views on what Ms. McCoy thinks. I know that's not quite how you framed it. Won't be so relevant, but I think it is, given the amorphousness of abstention, where we are right now, I'll let you ask Ms. Smith some questions in that area.
Yeah, and to be clear and to further preview, I'm not asking questions about what the definitions are, but what the practical effect would be when the hearing goes forward.
Okay, well, that's different, and that I'm all right with that. The one thing I just don't know how exactly the relationship between a board member and Ms. Smith works. If a board member comes to her saying, I've got this situation, could you give me counsel? Is that something you're allowed to ask about? In other words, is that a privileged communication? I'm not asking you to answer that, but you shouldn't be surprised if there's an objection. I just don't know the nature, how you would what the confines or protections would be for a communication that Ms. McCoy had with Ms. Smith about, well, what do you think I should do with this? I'm new, I'm reading these ethical guidelines. What's your counsel?
Yes, and to be clear, what we'd be asking for in that first category is what communications did Smith have about the facts of McCoy with the other board members? Do they know, did she have any conversations with the other board members about these facts?
Okay. All right, let's see where it goes, and you're free to continue to object.
Okay, and just for the record, on topic number 3, I just would ask that the court circumscribe the questions to within an area that, you know, what the board does and how they vote and things like that is not open to the public. Okay.
No, I agree. To me, it would be very structural. Has there been an instance when only 4 members were in the room and voted? Not how did they vote? Nothing like that. We'll both shut that down. But it would be, yeah, you know what? On Tuesdays, it's 3 for Tuesday. Only 3 people in the room. So, all right. Ms. Smith, you still with us? You are. Excellent.
And she's been listening the whole time, so now she knows what's coming.
Did Deputy Gordon leave? Deputy Gordon? All right, I'm going to try. You raise your right hand. Do you swear that you will tell the truth, the whole truth, and nothing but the truth?
I do.
Great.
Thank you, Ms. Smith. First question. Have you communicated about the facts underlying McCoy's potential conflict of interest with any of the other 4 board members?
I have communicated with the chair, Joyette Holmes, about the issues that have been brought to my attention by counsel for Mr. Humphreys. Mm-hmm. I don't recall having any conversations with the other board members about the issue.
I don't recall.
Okay, so that would, you said Miss, who was the person that you communicated with?
Holmes, Chair Holmes, Joyette.
Okay. And this was the Joyette Holmes, who was for a period of time the elected DA in Cobb County? Okay.
Yes.
Okay, so if we have a situation where Ms. McCoy is not recusing, but she is abstaining, can you give us any idea how that would work from a logistical, from a practical standpoint? Can you give us any guarantees about what that looks like?
I think how Ms. McCoy framed it with the court is we would the court provides.
I'm sorry, hold on, a cough obliterated what you said.
Sure.
Quit coughing, please.
We would follow the direction of the court. This is a case of first impression for us at the board, at least during my tenure. I've been with the board since 2005 and my current position since 2010.
I'm sorry, I'm having trouble hearing Ms. Smith. There's somebody that's not muted and their voices are coming through.
It's coming through Miss Smith's mic.
It may just be background noise of Ms. Smith.
It may be. We'll try again. So, Ms. Smith, you've been working with the board since 2005.
Yes, sir. In my current capacity since 2010.
What was your capacity for the first 5 years?
I was number 2 in this position. So I had a predecessor who was the director of legal services in 2005 to 2009, 10, something like that.
Got it. Then you got moved up to being legal counsel.
Right. That's right.
And when you say unprecedented, meaning in your 20-ish years working with the board, there hasn't been a situation where a board member has said, I've got a conflict, we need to figure out what to do with that.
Oh, absolutely. In a death penalty case, absolutely.
The lights just went off.
My lights go out when I don't move.
Sitting here too long.
Feel free to wave your arms. I can swear you in periodically. That'll get your arm up.
Wave your arms. Keep the lights going.
Okay, so I appreciate the representation that you will follow what the court tells you to do, as we all will. But in the absence of a court order, can you tell us anything about what McCoy will do or will not do in connection with this clemency hearing? Is she going to be there? Is she going to be allowed to talk? Is she going to be allowed to sigh? Can you tell us anything that we can take to the bank about her involvement in the absence of a court order?
Sure. My understanding is she would be she would not vote on the matter, but be present to hear the application and the information presented to the board in support of and or against clemency. And that would be the extent of her involvement. In addition to what you were asking, would she be able to ask questions? Yes.
Ms. Smith,
is that
when
abstaining
the
or
presentation is done, is it kind of like a jury trial and the people who presented leave and then the board members confer and say, hey, again, I don't want any substance of the conversation, but the process, they then talk about it and take a vote in private with no one present? Or do they, in front of everyone else, say, all right, what do you think? And they raise their hand saying, spare him.
They go closed session.
They have an opportunity to deliberate collectively. And then if they so choose to cast their votes are confidential and private. So they would designate their votes on a paper ballot and submit those ballots to me. They could do that in the presence of the other members or in private. And once the ballots are collected, I will get with the chair and we will go through the ballots and count up the ballots to come to determine what the actual decision of the board is.
Okay, and your vision as to what abstention would mean for Ms. McCoy is that she would be there for the entire presentation. She could ask questions, and then when everyone leaves, she could be part of the discussion, the post-presentation discussion. She just wouldn't, if this is one of the ballots, she wouldn't fill out one of the ballots.
This abstaining is very active.
Yeah, so that's my understanding as of right now. That could change based on the information that is indicated, that if the court decides otherwise, that would not be constitutional. But as of tonight, yes.
Got it.
Okay. And just as a practical matter, can we agree that for Mr. Humphreys, there is no difference in effect between a vote to abstain and a vote to deny? Those are, practically speaking, the same exact thing for Mr. Humphrey.
Yes.
I'm not sure I understand your question.
That's a good question.
Mr. Humphreys needs to get to 3 votes to be spared, correct?
Right.
And so a vote to abstain is effectively the same exact thing as a vote to deny from Mr. Humphreys' perspective, correct?
Counting, yeah.
Correct.
Okay.
That matters.
All right, and Judge already got us 99% of the way here. I want to direct your attention to a passage from Fugate and just make sure that we are in agreement about the unprecedented nature of this. So Fugate says, significant to the court, the respondents were unable to refute the petitioner's contentions that there has never been a death penalty clemency hearing without a full 5-member board, not only appointed, but indeed present at the hearing or at least voting after a review of the record and the papers filed by the parties. As you sit here today, to be clear, you are not aware of any death penalty clemency hearing without 5 board members voting. Is that correct?
Are you thinking, or did you answer and I missed?
I'm thinking.
Okay, keep thinking. I just wasn't sure that there's a cough and we don't hear you.
I'm thinking. I am not aware of a situation where we've had a death penalty case, clemency appointment or meeting, where 5 board members were not on the board and available to vote the case.
Thank you, Ms. Smith. No other questions?
Yeah, if she's not
Do you
there.
have questions for Ms. Smith?
Oh, just
Great.
quickly.
Okay.
Hi, Ms. Smith. So if all 5 members come to you separately and the first 3 vote for clemency, would you even need to have the votes from the 4th and 5th member?
You do not.
All right. And in your experience, have there been occasions where 3 came in one way or another and
to abstain?
You really didn't look at the rest, or you didn't get the rest, or whatever?
Yes.
All right. That's it, Your Honor.
I follow Ms. Piper's questions, but those scenarios are ones where nonetheless all 5 board members were present and able to vote, but it may be like, do you send up a smoke signal once there's 3? Because there's like no point in being number 4 or 5, because 5-0 isn't any better than 3-2.
So it depends, Your Honor, if all 5 are present in the boardroom after the appointment or the meeting and decide to vote then and there. Obviously, we have our votes and they're all in. If they decide that they do not want to vote in that manner, but want to take the matter under consideration privately, then a time deadline may be given or has been given as to when to get the votes in. And so when that deadline comes and goes, then we know whether we have the 3 decisions, and I will announce the chair will announce to the board members that a decision has been obtained and what that decision is.
Okay, got it. All right, thank you. Did you have any follow-up, Mr. Greenmeyer, after Ms. Piper's questions?
No, Judge. Thank you, Ms. Smith.
All right, thanks, Ms. Smith.
Welcome.
All right, any other witnesses?
No.
No, Your Honor, not at this time.
All right, any witnesses from respondents
No, Your Honor.
other than the ones you made available? And thank you for doing that.
We would ask if there's no further questions that they be excused.
Yep. So you are welcome to stay on our session. We're going to have a little more argument, but if you have other places you need to be, you are free to go. And thank you for your work on the board. What do you want to do next? I guess, Ms. Sino, you had a chance to do some arguing. I really haven't heard much from respondents. I guess I'd like to do that so that we can get a sense of where they think things are heading. And then we'll see if there's a need for rebuttal to that.
What do you want to do next?
Okay,
Thank you.
great. Ms. Piper.
Can you hear me okay?
We can hear you.
Court reporter?
I can.
Okay, great. Thank you. And since I have had the opportunity to argue a little bit, I will try and keep this very succinct and concise. I think that as you opened up in the beginning, this is a mandamus. I mean, there's a TRO, but they have to show likelihood. So we're going back to the merits. 2 issues. First issue is the abstention of voting. McCoy's out, so I feel like that's been mooted. You've heard testimony from Mr. Bennett. There's no personal involvement.
When you say that's been mooted, how do you navigate that ethical provision that says recuse as opposed to the introduction of the concept of abstaining, which doesn't seem to be in the ethical guidelines?
Yeah, there's a couple of things. One, you know, I think as lawyers, we are very cognizant words matter. So I would say, you know, you could look straight up to a Black's law definition of abstain and a Black's law definition of recuse and follow those. But I think also in terms of a board member who is not an attorney, you know, they may be morphing those together and understanding those together. Do you know what I'm saying? As a board member, you're like, oh, well, abstaining, I'm not voting, that is what I have to do to avoid this conflict.
Sure.
Right?
But it was your brief that said abstain. It wasn't, Ms. McCoy did not introduce the term into the process.
And you know, I would say that is a declination to vote, a removal of yourself from the vote, not a complete absence from the proceedings.
So if she is present but can't possibly vote for clemency, to a point that petitioner's lawyers made, then doesn't Mr. Humphreys walk into that room with fewer chances to get 3 votes? He has to bat 750 instead of 600. And doesn't that change the dynamic in a way that's not fair?
Well, I mean, that presumes, you know, that a vote's going to go any particular way, but that's not what the question is. Does he have a legal right to that?
You're right.
Not what are his chances, what are his odds? Does odds go up this way or go down that way? The question is, does he have a legal right to it? Yep. And we submit he doesn't.
Okay.
So, and back to the rules.
Your position would be he has a legal right to a quorum, which is 3.
That is
correct. If you walk in the room and there's only 1 person, that's not going to work.
Correct.
But if there were 3, if for whatever reason I were to find, gosh, Mr. Bennett, you're disqualified as well. The 5 times you may have been in the courtroom over the course of a month-long trial, that's too much.
Correct.
So you also have to abstain. There would still be 3 people who could vote, and that's a quorum, and that's the right that Mr. Humphreys enjoys, is having a quorum.
Yes, Your Honor.
Okay.
All right, and I can, you know, I think our brief is pretty clear and lays out. I want to just address that policy one quick last time, and I think I've already said this. You know, there's certainly, you could argue, you know, I just don't think that a written policy that the board adopts, modifies at will, changes at will, rises to a level of requirement that the Constitution is, right? It's a difference. And the Constitution, if we look at, and I'll just go straight to the heart of what they're pinning, you know, this whole linchpin on the constitutional provision, I think it's Article 4, Section 2, Paragraph 2D, you know, the chairman of the board, blah, 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 may suspend the execution until the full board shall have an opportunity to hear the application of the convicted person for any relief within the power of the board. It does not, first of all, it's not mandatory. It's he may, right? And that, when we say may, words matter. It's precatory. It's not mandatory, right? There's discussion there, but it's also the full board have an opportunity. It says nothing to the declination of availing themselves to vote, right? It just doesn't speak to that. There's a heavy emphasis on a case that is non-binding, that really, if you look at the holding, what fugate stands for at most is you got to have 5 members appointed. That's what the Constitution requires. We have that here. That hasn't changed. And, you know, I just, in our brief, it hasn't been really talked about much today. So I want to kind of go there and then hear from you what you'd like to hear from me. The relief they seek. I mean, they're not only is there no clear legal right to that relief, there is no legal authority to get there. There are 5 members appointed. The Constitution gives you 5. That's it. No less, no more. The governor can't appoint someone to fill any role of a member who's abstaining.
Because that would make 6.
Because that would make 6.
Because I'll tell you what I've wrestled with, the way it works with the Judicial Qualifications Commission. The hearing panel, so the body that would handle the trial of a judge, has 3 members. Every once in a while, the member may have a conflict. I did, because they were figuring out what to do with a judge on our municipal court. And the rules are real clear. You can't be the hearing officer or the chair of the hearing panel for a judge who's from your circuit. But that didn't mean we went forward with 2. it meant that the Chief Justice appointed another judge to fill the judicial position of the 3-member hearing panel. I don't know that that's all, certainly not in the Constitution. I don't know that's spelled out in the rules, but it was, we had to do something, because what is in the rules, what is in the policy is if you have a conflict, you recuse. I thought it could be fair, but it doesn't matter. It's a structural conflict. We're in the same circuit, so I shouldn't be in that group. So they find a judge from another circuit. She parachutes in and she handles it. Well, technically, did we have 4 people on the hearing panel at the time? You could count, and maybe, but one was interim while one was recused and not functioning as a hearing panel member. Isn't that how it would work here?
No.
No.
And you know, I
It's a
appreciate.
quick answer.
I appreciate that that is a system that you have legal authority to do under the JQC. That is not the case here. The Constitution is very clear, and the law is very clear about what authority the governor has with respect to that board. And he has 3 different scenarios where he gets to play, you know, remove for cause, remove because they're incompetent, or, you know, they're very, very, you know, incapacitated, unable to perform. There's no other legal mechanism for him to just like slide someone in there. And
he appoints everyone on, it's not like some of these government agencies where the president of the Senate appoints one and the Speaker of the House, the governor appoints all 5 members.
That is correct. They do have to be confirmed.
But the governor is the selector of, or propounds the nominees for each.
That is correct. And just, I guess, just to finish kind of where I was and got excited and moved around.
Sorry.
You know, I think at most, Fugate stands for that proposition that, you know, you have to have 5 members elected. So even, you know, and as we've set out, the law very clearly establishes, and it's in our brief, you know, under 4297, a quorum is all that's needed to quote unquote legally transact the business of the board. You know, that includes the board's business of ruling on a clemency application. That is the board's business. So even if 2 abstain, we have a quorum. And under Georgia law, the minimum number that we need for a quorum to conduct the legal transaction of the board's business, which here is review of a clemency application, is met. And unless you have further questions, we'll rely on our briefs.
I do have a question.
Okay.
Is there something in the law that says the governor could not appoint an interim board member?
Well,
or what you're saying is it says these are the 3, you can do it in 3 instances, because you've removed someone resigns, or the 3rd one would be, but because the law is silent about, well, you know, if someone says, because there's a policy that says you should do this, I need to recuse from this one. Let me ask it in a different way. What if 3 people had to recuse? Then there's no clemency hearing? You can't do it?
in that hypothetical.
That's my hypothetical.
Your hypothetical.
3 people are recusing. What do we do?
I would think that, you know, the governor would be faced with a decision on whether he would seek resignation of one if he needed to replace one.
So that someone would actually have to quit.
Well, here's the thing about the executive branch, okay? Typically, you have authority that is granted by the legislature, and it extends no farther than that authority.
At least in Georgia.
Which is either, you know, directly or by implication. There is not anything that I've seen that would say by implication he has this authority.
Okay. No, we're clearly in this liminal space. In my scenario, I don't know how you'd have 3 people who had a recusal, but it comes up, and then what do you do? Because you need a quorum, which would mean you need 3, and you don't, you only have 2. But the answer wouldn't be, well, then we're just not going to give you a clemency hearing. It's too bad that your situation was so high profile that 3 people recused.
Hopefully our board will never be comprised in
Let's
such
hope.
a manner that we
Yeah.
face that question.
Okay. All right.
Thank you.
Thank you. And I appreciate, this was dropped on your office with exceedingly short notice, and that's not a knock on the petitioners. Everything is rushed at the end, but you guys, it's always fire drills, and it's still well put together. So thank you.
I can't take credit for that. It was a team.
I figured it's not just one person, but that the team continues to deliver. So thank you. Ms. Sino or anyone else of the table of 5, but please identify who you are if you're talking.
Yes.
What do we do with you can't have 6, you can only have 5. And if really what has to happen is that Ms. McCoy should recuse and not participate in any way, because there really ought to be a chance to have 5 people to convince and not 4, because it really wouldn't matter what your team said. It's impossible to convince Ms. McCoy. That's the wrong way to put it. It's impossible to get a yes to clemency vote from Ms. McCoy because she's not voting, and she shouldn't vote. But then I agree with Ms. Piper. It's not right to say, well, now he has to bat 750, but factually, he has one fewer opportunity to convince someone to get a yes to clemency vote.
Right, which.
But you can't have 6 members.
You cannot have 6 members. You have to have 5. But under 4291, the governor has the opportunity, if he receives information deemed to be reliable, if a member of the board by reason of illness or other providential cause is unable to perform the duties of the office, he gets to appoint somebody new. And it doesn't have to be subject to the legislature confirming it. Right? If the legislature is not.
Someone new who forever replaces the person who's providentially unavailable?
So this is the part under D, any such appointment, if it's made at a time when the Senate's not in session, can be effective ad interim. It can be interim.
Okay.
The legislature is not in session right now.
But what if it is? What if, because this has been,
Judge McBurney likes
assume for a
to
minute
flesh
there's some
out
master
the
chess
full
players
scope.
here, and like, hey, well, I guess though after the 24th you have to get a new warrant. But anyway,
What
there's a
if
new
it
warrant,
is?
execution warrant that's secured, and now it's time to have the hearing, and it's March 10th. Legislature's in session, and Ms. McCoy is going to remain providentially unavailable for purposes of your client's clemency hearing. What then? He has to go to the legislature to get an interim appointment, or bizarrely, interim appointments are only available when the legislature's not in session?
Well, no, I mean, there is a whole process that is set out, right? If we start with Section A, he has to call a council to be composed of the president of medical association, et cetera.
I'm sorry, I can't hear you.
I'm sorry, and I didn't, okay, 4291?
Yes, no, that's on my computer. It is
asking what you're referring to.
Sure, OCGA 4213-2.
So hold on, you've pivoted. You had said 4291. Was that a miscite?
Sorry.
Or both statutes at play here?
Sorry, I'm looking at the very top of this. It's 42-9-12. My apologies.
So neither. All right.
912?
42-9-12.
Got it.
My apologies.
That's okay. I
And
just
this is,
wanted to make sure we're reading the right statute.
yeah.
All right, 42-9-12.
42-9-12, governor receives information, somebody is unable to perform duties of office. He shall call a council composed of the Medical Association of Georgia, president of the State Bar of Georgia, commissioner of public health, to determine if that individual is not able to perform duties. He can appoint some other member. Right.
they going to go all night arguing this?
What?
You have to stop eventually because
Yeah.
dinner's ready.
And it operates as a temporary suspension.
Okay.
It's just a temporary suspension.
Okay. So 42,912, I'll have to explore that. But you made it seem like it was contingent upon the legislature not being in session. I don't mean to put you on the spot. I'm gonna read it and I'm gonna give people a chance to respond to that, but.
I was looking it up as she was stating that we can't have a sixth person.
But we can.
But because it does state,
guess we're
let
still
me see. Good.
This is death penalty argument stuff, and I love it. We don't get to see a lot of this.
Yeah, it's D. If the Senate's in session, it has to go through the Senate. If they're not, it's ad interim. And that's the statute.
But if they're in session, it goes through the Senate for them to approve the interim person, or it's a completely different beast? It's the same concept. Someone is providentially unavailable, and if they're not in session, then the governor plus this board would decide, here's our interim replacement. But if someone is providentially unavailable, I broke my leg and I can't, it's really painful and I can't come, we got to do the clemency hearing, they can draft a substitute. And either it's Senate approved if they're in session, or it's special board approved if they're not in session.
So it seems to indicate that it is interim because then Part E says during the period of incapacity of the member of the board, the member shall be entitled to receive compensation and other benefits.
Okay.
So
I'm going to have to get cozy with 42,912.
42,912.
All right.
It's an interim seat. The appointment whether ad interim or Senate. There's a permanent nurse or an interim nurse. Doesn't make sense. So if you appoint somebody for the interim, the way the appointment is made to the board is either if the Senate's in session. Right, or not. But it's just interim. And it also applies to those two things. Like we're mixing those two things together. Do you see what I'm saying? Like they're an interim seat.
They're an interim seat no matter what.
Right. And how they get appointed just depends on whether or not Senate's in session.
Right. I think that's what I
said.
I think that's what I stated.
Okay.
They're an interim seat no matter what.
Okay.
And either there's an appointment process out of legislative session or in.
Understood.
Yes.
Other things you wanted to add?
Other things I do want to add. If I can share a PowerPoint.
How long is the PowerPoint?
12 slides.
What's it about?
Just detailing the Georgia Constitution and I can just briefly summarize. How about that?
Excellent.
Does that make it? Yeah, it's late.
Let's make it quick.
I want to say earlier you asked for a hook on the ethical guidelines. So OCGA 45-10-3, those impose mandatory duties on employees, on our officials, and that's where the hook is. They have to follow their ethical guidelines. That's the statutory provision.
All right.
I also want to talk about the abstention. Abstention does not fix the problem. Abstention means we effectively have Mr. Humphreys starting one vote down, a no vote, and that is not constitutionally effective. It means Mr. Humphreys already has one vote going in that's no, and the Constitution states that it has to be 5 votes. And I know they want to really parse the words and say meaningful deliberation. As long as she's not voting, we fulfill our requirement for 5. But under OCGA section 42-10, 6-9-20. In all cases in which the chairperson of the board or any other member designated by the board has suspended the execution, which has occurred, of a death sentence to enable the full board to consider and pass on the same. Consider and pass on the same. That sounds like a vote. It shall be mandatory that the board act with a period not exceeding 90 days from the date of the suspension order. And I realize that's about the 90 days, but it contemplates that they are passing on that. They're not sitting there and listening and simply occupying a seat.
Okay. That was a good summary of the PowerPoint. I don't know, it was in the PowerPoint, but it was a lot faster than 12 slides. Thank you.
And then finally, there is one last part, which is fugate. We are in the fugate situation right now. There are only 4 members because the abstaining member can't vote.
This is Georgia versus
And fugate
Stacey Ian
requires
Humphreys.
to have that 5th vote, not a 5th person, a 5th vote. And it's very, very important because clemency is so different.
Why is clemency different? Meaning because the outcome of a failure to get clemency is fairly profound.
If Mr. Humphreys has an execution, let's say they restart that clock tomorrow, we're going for a clemency hearing, there's an execution, whether it's Thursday, Friday, or next week within the warrant period. The next day, we can't wake up and say, oops, we got it wrong. There has never been 4 people voting. They said that themselves, and at least since 2005, there hasn't been 4 people with a vote and just a no, just going in 1 vote down. That seems ridiculous to say we're going to start that today.
I think they have a point.
And fugate stated,
I think this whole thing might be moot. I don't think he's going to get 3 votes.
The opportunity to present a case is
2
unique and firmly rooted in the criminal justice system when it comes to clemency. A 5th board member might be persuaded by the petitioner's case and may well be able to move others on the board to favorably consider a reprieve. It cannot be discounted, that 5th vote, that 5th member.
She's almost getting emotional over this.
That's all I want to say.
All right. Thank you.
Wow. Her heart is in that argument.
Ms. Piper?
Very short.
That's okay. You have listened mostly this afternoon. So if there's one very short thing or some short thing you want to share, let's do it.
All right. Just, I'd like to point out incapacitation, providential cause, do not in any way, we're shoehorning conflict in there. It's just not applicable. And then I would like to, again, the 5th may talk them into clemency. The 5th may talk them all into not giving clemency. That's all speculation, and it doesn't matter because at the end of the day, yes, death is irreparable, but he has no right beyond what the state of Georgia has provided him in his application for clemency. So you can't say he's harmed if we are providing that option as dictated by the mandates of the Constitution and state law. That's all.
Okay. Thank you.
Your Honor, can I add one more thing? Sorry, it's very quick.
Okay.
That suspension can be lifted at any point. So the TRO is incredibly important for the 90-day stay, for them to appoint somebody new. That if they lift that suspension, we have to go right into clemency proceedings, and we don't even have the witnesses ready to go. If that thing's not occurring tomorrow, then we don't know when it's happening, and we will not be prepared.
Let me ask a little bit more about that, and you don't need to worry about responding to that. That's an important point, just different from what we've been focusing on, is you or your colleagues have brought it up several times. So I've never been to a clemency hearing. Apparently, it's not just one witness saying, hey, show some compassion. It sounds like you have a whole host of people you intend to call, and they were lined up for 9 a.m. tomorrow. So there are people like landing at Hartsfield right now who are going to have a great dinner and then be told, get back on the plane because nothing's happening.
And I'll let my colleagues speak more about the.
Well, I don't, because it's 5:40, want to get into all the blocking and tackling involved. You're helping me understand. It's not just the lawyers and then Mr. Humphrey's mom saying he was a good kid or he was an abused kid. It sounds like there are many, many, many moving parts. And so being told, hey, let's do it next Monday instead isn't necessary. As much notice as possible is critical to get all the people there.
Absolutely. It's mental health professionals, it's character witnesses, it is the lawyers, but it is a large moving machine. It's almost like a mini mitigation trial.
How much notice did you have that the clemency hearing was going to be at 9 a.m. tomorrow?
Your Honor, this was a quite a short warrant and we did not see it coming. It was.
I'm sorry, I can't hear who's speaking.
You know how it works in here.
Beth Wells. We got the warrant December 1st, and we were caught off guard by it because for things not relevant to this court today, we then had to quickly move to get people brought here. It is right before Christmas, which has made things incredibly difficult.
Okay, but my question is, yes. So you were able, so tomorrow's the 16th. So in basically 2 weeks, through Herculean efforts, you were able to get everyone there. Anything shorter would be even more difficult to do. Got it.
Yes.
And do the way the warrants work that they could apply for a new one and hold on one second.
We're holding, Judge. We're in a holding pattern. But my family's not holding off on dinner. I can hear them eating in the background.
Could you get not you wouldn't obtain it, but could the district attorney obtain a warrant that, I'm making the dates up, but because the 24th is when, this one expires. So what would happen? They could unsuspend that the board could, on the 22nd, say, we unsuspend, clemency hearing is tomorrow, the 23rd, and execution is Christmas Eve, 7 p.m., because the warrant expires at 10 midnight on the 24th. That is procedurally permissible.
They could unsuspend the minute we walk out of this courtroom.
Okay.
And they have unsuspended a day after they've entered the order suspending. We have had that happen.
In other cases?
Yes.
Okay,
So
got it. So this is you're flying blind as to what's going to happen.
And yes, and that is why we're requesting that they sign a TRO, or at least to the extent of not having an execution under this warrant.
Okay.
Until the court rules.
Got it.
Thank you.
Okay, you're welcome. It's a new set of mechanics. Okay, so I need to get Ms. McCoy's records filed under seal. That's one part of that set of documents. I'll look through the other part to see if there's anything that needs to be disclosed that it relates to Mr. Bennett. And then there's the question about the TRO just to maintain the status quo, which today the status quo is that the execution or the warrant is suspended. And that's the status quo that a TRO would maintain. But the more fundamental ruling is when there is a clemency hearing, who is up? Are they at a dais? I don't know how they sit, but who is Ms. McCoy up there? Are there only 4 people there, or are there 5 people? And it involves this interim appointment. Okay. Anything else from petitioner?
No, Your Honor. Thank you.
From the respondents?
Just one housekeeping, and I think I heard that you understood this. I just want to make sure you did. The order from the board the suspension has to be lifted before a new warrant can be sought for execution if the warrant that we're on now expires.
Got it. So no, but I'm going to play this back because I didn't know that. Not because someone told me something contrary, but this order suspending means the execution can not go forward until it's lifted. If this order is in place and I'm opening Christmas presents, then the warrant has expired and no new warrant can be sought until this order is lifted. Once the order is lifted, someone can seek a warrant, and then how long does the warrant live?
It's 7 days.
Ayden, how's it going?
Oh, it's just 1 week. Oh, okay.
Listen to a death penalty argument last minute.
I'm sorry, I can't hear who's speaking.
I'm sorry, it was me.
We're going to go off the record now, okay? I'll let you know when we're back on the record.
The judge is so mad
When
at
a
her.
warrant is signed, they have to be, the execution period starts between 10 and 20 days from the warrant, when the warrant is signed, and then it's a 7-day period. So it can be up to 17 days or up to 27 days.
Okay.
At the length. And just
Complicated.
it is.
Okay.
To clarify, Your Honor, you are correct exactly what you said. If we make it to Christmas Day and that's still in place, they would have to seek a new warrant. Our concern is between now and the 24th, if they tear that up.
I understand. No, I got that. It was helpful to know that if this isn't lifted, then they can't even get another warrant till this is lifted. How do I learn when this is lifted?
We would offer to ensure that the court got notice if it were to be lifted.
That would be great. I may need to enter an order to that effect, that I'm on the hotline. I trust that this team is on the hotline.
They are on the hotline.
Yeah, I just want to be added to the hotline. And the decision about lifting this is purely internal. It's the board. They confer. They figure out what they're doing with whoever their muses are. It's
Chairman or the designee.
okay. All right. Let's get back on the record.
Back on.
Thank you. All right. I will keep working on this, and I will certainly reach out if I have questions. Emails will always go to both sides, and we'll see what we can do with this. If anyone ever has a question, just reach out to Ms. Niles. Email is the most direct way to get to her. She'll let me know, and we'll work through it. And again, thank you to both sides. Everything is always so compressed as we approach that deadline. And it involves so many different layers of courts. We even have the feds poking in here. So I appreciate everyone's focus. And with that, you all need to settle up with our court reporter. She has done an excellent job of keeping us near microphones so that she's able to make an accurate record of the proceedings. So thank you for that, Ms. Nichols. And I'll rely on petitioner's team to get those exhibits to Ms. Nichols. Okay, well, just make extra sure. All right, thank you, everyone.
Judge McBurney, thank you for...
Okay, who is Beth Wells representing?
Here she comes.
This is going to pay your bill. I'm with Stacey Humphreys, and I will reach out with you as soon as I get back to the court about what we're doing.
Okay.
And how to get paid.
Okay. Well, I was under the impression by what y'all said that y'all are splitting the bill for the transcript to be expedited and the court reporter. That's what y'all said at the start.
Correct.
That's still true.
Okay. Okay. And Ms. Wells, I need you to send me your, what firm are you with, Ms. Wells?
It's with Ms. Conrad from the Federal Defender contacted you. That we are with the Federal Defender.
Okay, I have no idea who contacted me.
Oh, okay. Right.
So
I'm with the Federal Defender program. I'll send you all of that information as soon as I just don't have internet connectivity.
I totally understand. If you'll do that ASAP, I'd appreciate it.
Thank you so much.
Thank you. Bye, y'all.
Bye.
Thank you very much, Ms. Nichols.
You're welcome.
Bye, y'all. That's a great way to end the day today. Bye, y'all. Oh, man. Doesn't get any better than that. Very intense discussion. Very intense. Sorry, you see me shopping Black Magic Design switchers. Yeah, good stuff over here. All right. Whew. What a long day. It's almost 6 o'clock. If few of you are still stuck around. Some of you might be asleep, and this music might be waking you up. I apologize for that. There's a handful of you here. Get that soundbite. Bye, y'all. Bye, y'all. Let me stop this. There we go. All right, we're gonna leave that one where it is. Very interesting to watch the legal proceedings that take place in the last few hours of a death row inmate's life. That's what we're seeing right here play out in Mr. McPurdy's court, which is just amazing. All right, tonight when you go home, please hug the people you love. Smile at someone to make their day just a little bit better. Please stay safe until we go live again tomorrow morning. Are we going to follow this through? Hey, well, for what we can, yes. I'd like to keep this on the radar. I want to see how this happens. I'm sorry, Josh. I don't have much faith that Georgia's going to do right here, right? They've burned me before. And I just hope that they do right here. I'm not saying I'm going to say no death penalty for Mr. Humphreys, but I do think he should have at least 5 people who decide whether or not he dies or not. So, all right, that's it. Thank you very much. We can all go home now. Red Pen, thanks for coming back. Sorry about the headache. Josh is like, apology accepted, I guess. I'm sorry. Josh is in Georgia. What can I say? All right, y'all. You have a good night. We will see you tomorrow. I'm going to go see if there's any food left over if the family's eaten it all. You guys have a good one. We'll see you.